All right, I saw we have a written motion for directed verdict on behalf of Mr. Kendrick. Is there a separate one for Mr. Stillwell or you? Okay. All right, Mr. Kendrick, you want to present yours? I haven't had a chance to read it, only see that it got.
It was last minute, Your Honor, so.
No problem.
Good morning, Your Honor.
Good morning.
Let me begin just by stating that Mr. Shart and I last night went through a number of the predicate acts and overt acts that are in the indictment, and we've kind of made a detailed list of those predicate acts that we do not believe have been presented at trial.
Okay.
And I'm going to let Mr. Shart speak to that when he makes his motion orally this morning. I join in all of those that he does. And we are moving for a directed verdict on each of the counts against Mr. Kendrick, counts 1, 2, 50, and 57 through 63. And I'll go through each of those in order.
All right.
We're also moving for a directed verdict as to those overt acts that are before the 5-year date, before May 10th of 2017 in the indictment. Based on where we're looking at the jury instructions and the law, my understanding is that the jury is going to have to find at least one overt act that occurred after May 10th of 2017.
Right.
So I believe it would just be extra work for the jury and potential confusion if they were to sit there and go through each of the overt acts before May 10th, 2017. I understand that the state is allowed to put those into the indictment for a number of reasons. I understand that they like them in, or they want them in there in order to be able to quote unquote tell the whole story of the alleged racketeering activity. But since none of those overt acts can be used to support the any racketeering conviction, I don't believe that those overt acts prior to May 10th, 2017 should be before the jury for a decision. As to, just turning to the details of the different counts, as to count 1, Your Honor, the RICO count, in that situation, in that count, I don't believe the state has shown evidence upon which a rational trier of fact could find an overarching conspiracy seeking to achieve an overall common goal as required by the law. The state has shown a number, quite a few, I would agree, a number of individual acts they've presented. They have presented a number of crimes and alleged crimes committed by co-conspirators. But I do not believe that they have presented to this jury any form of an overarching conspiracy that would tie those acts together. The second part, I don't believe that the state has presented to the jury an enterprise that would be required, at least a criminal enterprise. I do appreciate that perhaps they don't have to show that the enterprise was criminal in nature. So I'm not going to spend a lot of time on that. I don't want to take up the court's time. I have some things in my written motion. Third, a pattern of racketeering activity is required for the RICO. This pattern, as you know, requires two predicate acts. They have to be within 4 years of each other, And the key that I want to focus on is that these acts have to be interrelated. And it's the interrelated portion of the statute that the state has not shown for the jury, and that a rational trier of fact could not find. Again, after watching this trial for a year, it's clear that the state has put on evidence of various crimes and alleged crimes. They've put on witnesses. They've had testimony from individuals that are alleged members of this conspiracy that have taken the stand and admitted to committing particular crimes. But they haven't shown at all that these crimes are interrelated. In fact, when the witnesses have taken the stand and they've been questioned, in response to questioning, they've stated, I would say universally, I mean, it's been a year, so I don't know that I have everything in my head, but I believe they've stated universally that they committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all. There's been no demonstration, for example, of money flowing up and down the organization, and they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. It's as if the state believes if they just show a tremendous number, and I guess we have close to 200 acts, if they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient. They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac and inside of the Texaco station. This Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti. And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they've presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviewed, they have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Shart so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although, again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas. Last, Your Honor, counts 57 through 63. All of those counts relate to the activity, the raid on Jeffery Williams' house on May 9th, 2022. Each of those counts is either specifically gun or a gun count or a drug count, or they're predicated on a gun count or a drug count. There has been zero evidence of Mr. Kendrick in actual possession of those guns or drugs. I'm sure the state will argue that he was in constructive possession. And I'm assuming they're going to argue this because they have two pictures from Mr. Kendrick's phone that were on his phone, that were modified on his phone on May the 9th of 2022. There's been no testimony presented that those pictures were taken by Mr. Kendrick. The only evidence that has been presented is that those pictures are of the inside of the house. So, but let's assume he's inside the house, even if you want to make that assumption. There's been no evidence of constructive possession because there's been no evidence presented of any intent or ability or intent of Mr. Kendrick to exercise control of either the drugs or guns in that house. Zero on intent and zero on his ability to access those weapons and drugs. Last, Your Honor, with respect to count 63 is the 133 charge against Mr. Kendrick. As we discussed previously in court, there's an essential element of 133 that has been left out. So I believe a directed verdict on 133 would be, on that count would be appropriate.
Let me interject and ask you, I saw that Mr. Abadi had sent something that addressed whether, even if directed verdict is appropriate on that, a lesser included. Can you address that?
Sure. I saw the one specific case that I saw that would support Mr. Abadi's position was Martinez v. State, 318 Georgia Appeals 254. And that case, from the limited time I had to review it and do further research, does appear to support Mr. Abadi's position regarding 131 being chargeable. But that case, I cannot find a single other case that follows that case. I also, just again to be candid with the court, I don't see any case that says that case is wrong. But I would argue that the 131 count should not be charged to the jury, if for no other reason than the state puts that 133 charge. Well, I don't know what the state's motives are, but I would argue that the motives of charging 133 versus 131 is that 133 carries significantly higher penalties, and that they put in 133 in order to have greater leverage in plea negotiations. And I don't think, after having used that leverage for the past 2 years, that they should now that they can't prove up the 133, should be allowed to reduce it to the 131. But I cannot argue right now before you that Martinez does not support the state's position, Your Honor. And then again, I'm going to adopt whatever arguments that Mr. Shart is about to make on behalf of his client that would also apply to Mr. Kendrick.
Okay. So, Mr. Shart, I guess there's overlap on counts 1 and 2 for these two defendants, but those are the only counts that overlap, right?
Yes.
Yes.
Yeah, I believe that's
Okay.
right.
All right.
Do you have any further questions for me, Your Honor?
No, not right now. Thank you, Mr.
All right, thank you, Your Honor. I'd be happy to answer any other questions you have.
Appreciate it.
Good morning, Your Honor.
Morning.
Okay. So, I have arguments regarding several different counts in this indictment, as well as some of the overt acts, which I believe also need to be addressed, the alleged overt acts. And there's different arguments for different counts and alleged overt acts. I'm going to start with dealing with this argument applies to the RICO count.
Can I ask you something
Yep.
before you get
Yes.
started that might assist me? I think Mr. Weinstein said you might have a chart. Do you have something that's shareable with the court, or
I
is it-
don't. I don't. A chart is overstating what it is.
Okay.
We were trying to determine what specific counts, what
Okay.
evidence has been provided to the jurors so far in this trial.
Okay.
So let me just give a little background. I'm going to ask the court to consider Ruan v. United States, RUAN v. United States, 142 Supreme Court 2370 to 2022 case. That case explained that the commonly understood rule that as a general matter, our criminal law seeks to punish vicious will. Consequently, when courts interpret criminal statutes, courts start with a long-standing presumption traceable to common law that the legislature intended to require the criminally accused possess a culpable mind state. Applying the presumption of scienter, courts have been legally mandated to graft the material elements of mens rea into criminal statutes that are silent on the required mind state. Okay, and to bring it to this situation, the RICO statute is silent as to mens rea for the accused, as is, well, and not so much mens rea. Well, it is mens rea, but there's also an aspect of this that will apply to the gang statute as well. In United States v. Resendez-Ponce, 549 U.S. 102, it's a 2007 case, the United States Supreme Court wrote that the elementary legal principle is that every count of an indictment must set forth all material elements of the crime charged in order to be valid. In Division 2B of Elonis, E-L-O-N-I-S v. United States, 575 U.S. 723, it's a 2015 case, our highest court again taught that the fact that if a statute does not specify any required mental state, it does not mean that none exists. The Elonis court explained that courts have repeatedly held that the mere omission from a criminal statute of any mental or criminal intent should not be read as to dispense with this essential element. The rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. In other words, just because there's no mens rea listed in the criminal statute does not make it a strict liability crime. Okay, going to the indictment in this case. Count 1, RICO. Mr. Stillwell and Mr. Kendrick, to be guilty of count 1, the jury under the law would have to find that Mr. Kendrick and or Mr. Stillwell joined the conspiracy knowingly and willingly. The state, I'm going to ask Your Honor to consider the Cotman case, C-O-T-M-A-N v. State, 342 Georgia Appeals 569. It was a conspiracy to commit RICO case. That indictment alleged knowingly and willingly. My understanding, I have not seen the indictment, but I've been told the Trump indictment also includes knowingly and willingly. In this case, the state has not alleged, and the grand jury did not return a indictment, a true bill, alleging knowingly and willingly. The indictment for count 1 is missing an essential element that has been required by the case law. Although OCGA 1614.4 fails to include knowingly and willful mens rea requirement as discussed above, when the statute is silent on mens rea, courts define the proper mens rea requirement to avoid it becoming a strict liability crime. I will point the case to Wetzel, or I think it's Weitzel, v. State 298 Georgia 20, that discusses the concept of just putting unlawful. Does unlawful, as the state did here, does that cover knowingly and willingly? Is that an effective substitute? Our position is it is not. We believe that the Weitzel case supports that. So, Your Honor, we believe that the RICO count 1 is missing an essential element that has not been required by statute, but is required by the case law. And because that knowingly and willfully requirement, that mens rea requirement is missing from the indictment, count 1 is subject to a directed verdict, a general demur and directed verdict as it applies to both Mr. Stillwell and Mr. Kendrick. Now, turning to the gang counts, and I can get you the specific counts when I have a moment to look at the indictment. But going to the gang counts, the requirement, again, the gang statute under the Georgia Code is absent as to an essential element of the crime, which is in furtherance of the gang. That statute was in constitutional jeopardy before the Rodriguez case. The Rodriguez case saved the statute by adding an essential element to the gang statute, which is not only someone associated with the gang committing one of the specified crimes under the Gang Act, and the existence of a gang of 3 or more people. But additionally, Your Honor, they added, to save the statute constitutionally, the Rodriguez court added the requirement that the alleged illegal act must be in furtherance of the gang. The indictment in this case for all of the Gang Act violations, all the alleged Gang Act violations, none of those alleged Gang Act violations on this indictment returned by the grand jury allege that the act committed was in furtherance of the gang. Now, we know that that must be proven. The jury charges that we're going to give the jury list in furtherance of the gang as an essential element of this crime. And it is absent in all of the Gang Act violations alleged in this indictment, as the indictment for those counts does not allege every essential element of the crime. Those counts are subject to a general demur and a directed verdict as well. So that's one aspect of my arguments. I can move on to my other arguments, or I can put a pin in it.
Give me just a second.
Thanks, I appreciate it. And Mr. Abate just gave me, just helped me out, and I appreciate that, Mr. Abate. I'm referring to count 57 for Mr.
50,
Kendrick, and
51,
50 and 51.
57.
Yeah.
Thank you. Okay, go ahead.
So, moving on to the overacts, and I adopt Mr. Weinstein's arguments regarding count 2 as well. Moving on to the alleged overacts.
Can you actually, I mean, you can adopt those, but do you have anything to add with regard to count 2? Because Mr. Weinstein was basically talking about, the evidence or lack of evidence as to his client specifically.
The only evidence against Mr. Stillwell, there's no cell phone evidence. There's nothing of that nature. There's no identifications from the scene. The only evidence are social media posts and the testimony of, well, not the testimony, the out-of-court statements by 2 individuals, one being Quindarius Zachary, who completely disowned what he said, and back in the interviews when he was under the pressure of incarceration, under the pressure of prosecution, and we pointed out, hopefully effectively, that Mr. Zachary's story about this confession changed in material ways from when he told the story in 2015 to when he told the story in 2017. When this confession allegedly occurred changed, what was said allegedly changed, the circumstances changed, and then Mr. Copeland, I mean, you were here for that. He made out-of-court statements under the pressure of incarceration. He's openly admitted he would have said anything to get out of jail, to avoid prosecution, to avoid Rice Street, and his statements were not even that he witnessed anything, but he was told something by someone else who did not testify. So that is as far as I can tell, the entire university evidence against Mr. Stillwell, and our argument is that it doesn't clear that hurdle of surviving directed verdict.
All right.
So moving on to the alleged overacts, and I'll point out in this indictment, it lists, this is a conspiracy to commit RICO. So they don't need to prove the predicate acts. Those 2 related events within 4 years apart, they don't need to prove that, because all they need to prove is a conspiracy and 1 overact. So,
well, a conspiracy to commit 2 interrelated racketeering acts in furtherance of the enterprise.
yes, okay, that is fair, but they don't have to prove that the acts actually occurred.
Agreed.
So on page 14 of their indictment, it starts part 3, acts in furtherance of a conspiracy. It says, in furtherance of the conspiracy and to effect its objectives and purposes, the defendants committed and caused to be committed, among others, the following overacts, certain of which constitute acts of racketeering activity. So this part 3, this isn't about, they identify some things as overacts. They identify everything as an overact, but they also identify certain things as falling as a predicate under 1614.3 for racketeering activity. The nature of this allegation is it's conspiracy. So they don't have to prove that these predicates occurred. So essentially, my reading and my argument is that part 3 is essentially a list of overacts. That's what it is.
Yeah.
And we are all of the same opinion we're giving the jurors a jury instruction. It's clear, it's in the statute that the statute of limitations for the overt acts is 5 years before the date of indictment. And that's going to be, my understanding, that's going to be charged to the jury. So I, as a general principle, I do not understand if they only need one overt act, okay, and that overt act has to be within 5 years of the date of indictment. All of these other alleged overt acts that can't count, can't be used, and are completely not needed. I could see a situation, for instance, if they needed to show 2 overt acts, and one had to be within 5 years of the indictment, but one didn't, okay? It was just the last one needed to be within 5 years, but they needed to show 2. I could see the need for all of these other allegations, but that's not the case. They need to prove 1, according to their arguments, and it has to be within 5 years of the indictment. So everything that predates that cutoff date, which I think would be May 10th of 2017, it can't be used to convict.
It's not sufficient.
Well, but it doesn't add anything either because you only need 1.
Well, they also have to prove a conspiracy and an enterprise, and so.
They do have to prove a conspiracy and enterprise, and I'm not arguing that they can't argue about these things in closing. I'm not, I never argued that they couldn't get into these things, but they shouldn't be alleged in the indictment going back to the jury because we're telling the jury, we're sending the jury a completely mixed message. We're saying you can't find an overt act that
We're not saying that. We're not saying you can't find an overt act before the 5 years. What I will be saying is it is necessary if you want to convict,
right?
that you find, or if you believe there is evidence sufficient to convict, part of that evidence has to be an overt act within 5 years.
But by definition, no, I'm not, believe me, I'm going to fight tooth and nail about any duty to convict language, and I don't think there is any. But in layman's terms, if they find an overt act within 5 years, that is legally sufficient
Correct.
to authorize a conviction, which would make all of these other.
I hear what both of y'all are saying on that, and I just don't think I'm convinced that it should not even be presented to the jury because it's not sufficient in and of itself. But go ahead.
Okay, and
I mean, that's not exactly directed verdict issue anyway.
no, but I believe it is. I would say at this point, it is mere.
Surplusage.
Yeah, mere surplusage, I would say, and that it's going to confuse the jury to have this list of alleged overt acts where legally none of these prior to May 10, 2017 can be used to authorize a conviction on the overt acts for the overt act element of the RICO conspiracy. So, and then additionally, Your Honor, in all candor, we stayed after court. We went through all the charged offenses in the indictment, all of the alleged overt acts in the indictment, and we did our best. We didn't have the evidence in front of us. We did our best over the night, over the evening and this morning to go through those, and we either said we're not challenging it, we recall that there was evidence that would survive a directed verdict, we were unsure, or we're pretty certain there was no evidence of this.
Okay.
And so, but, it's a long list. And probably, I would suggest, to Your Honor, for that part of this argument, it kind of be more of a back and forth as opposed to me just listing off a bunch of numbers. I can.
Well, I've got to know what you're alleging.
Okay.
Are you talking about, like, help me out, which overt acts you think there is no evidence presented for?
Yes.
Okay.
As well as predicate acts.
What's that?
As well as predicate acts.
Yeah, but they're,
You have the list?
Have y'all talked to the state about this at all yet?
we haven't had an opportunity.
Does the state acknowledge that there are maybe at least some overt acts that no evidence was presented on?
Yes, Your Honor, and
Okay.
we don't intend to have that go back to the jury, and so we can discuss with defense
All right,
counsel
I
those
can
acts.
certainly let y'all do that, and if there's some that, I mean, I know there were at least a few that no evidence got presented on. So to the extent y'all can reach agreement, that would be fine, and then if we want to take it up later in the afternoon after y'all have gotten a chance to get together on it, that'll work.
Okay, thank you, Your Honor.
And there may be some y'all want to argue about, so we can do that later. So that's fine.
Okay.
Okay, and then do you want to argue specifically as to the other counts against Mr. Stillwell?
Well-
We've done kind of 1 and 2 at this point.
Right, I've argued the gang counts.
Oh, right, and yeah,
And I've argued the RICO. The Shamal Drinks alleged murder, I think the video speaks for itself. I don't believe that there's sufficient evidence that would authorize a rational juror to come back with a guilty verdict. We heard from Dr. Stanley, the ME. She was clear. Mr. Abate asked if someone's foot could stay on the brake, and she acknowledged that a foot could come on the brake and stay on the brake after being shot in the neck. And I asked, what about lifting the foot off the brake and putting it back down? And she said that would be an impossibility. We see clear from the video that Mr. Stillwell was, I think, gone. I'd have to review my notes, but I'm going to say it was about 26 seconds, I believe, between when his car left and when that brake light on Mr. Drinks' car was going on and off. Additionally, we have the U-turn. Additionally, we have the negative gunshot residue test. That we have no muzzle flash. It seems to me that we would have a muzzle flash. If we don't have a muzzle flash, the logical conclusion would be the shot was fired from inside the car. We have a negative gunshot residue result. And we heard from Mr. Coven from GBI. He followed all the procedures. Although there's been speculation and, of course, the grave suspicion jury instruction that we all go by, we're not supposed to speculate. We're not supposed to use conjecture, I think is the word that they use. And there's just a lot of speculation. Well, what if this happened? What if he cleaned the car? And there's no evidence that supports any of those theories. So the Drinks murder, as well as the associated charges with the Drinks murder, which would include a gun charge and also a gang charge, I believe, would also be subject to a directed verdict. As it applies to the final gun charge of Mr. Stillwell's on the 17th, I'm not going to argue that there's not evidence that could survive a directed verdict. You know, we've heard it was the gun that was found on Meadowlark was registered to Taisha Alexander. We've heard Taisha Alexander is Mr. Stillwell's girlfriend at the time. But I will adopt Mr. Weinstein's arguments. This was indicted as 16-11-133. We were put on notice for 133. It's missing an essential element. And we're going to argue that the state should not be able to alter, on the eve of closing arguments, alter the charges. And also, I'm not even sure about the mechanics of how that would happen at this point. It's charged under a certain statute in the indictment. I guess
Well,
if
I
it were
think it would be just like we always do any kind of lesser included offense. I mean, that's their argument is, yeah, we may not have the elements, and they certainly don't have the elements for 133, but we have the elements for 131, and that's what should get charged instead.
Okay, well, Your Honor, every time that I've dealt with lesser included, it's because there's some sort of, maybe not surprise, but the evidence didn't come across quite as we were expecting or the state was hoping, or the defense requests a lesser included. We're not requesting a lesser included, first of all, but they put us on notice to defend against 133, and they left out an essential element, and now we're changing the charges on the eve of closing arguments. So that's my argument regarding that.
Your Honor, to aid an argument for the court, I'm going to be addressing the demur regarding count 1 RICO. And if the court has further questions on the lesser included of the 131, Mr. Abadi's going to address that. Mr. Floyd, if the court regarding the Rodriguez case, which was a case he handled on the demur on the street gang, if the court has more questions on that. And then Ms. Hilton would handle the remaining counts other than count 1. I just wanted to give the court that overview.
Thank you.
As the court's aware, Your Honor, the charge as alleged, the conspiracy, the state believes that there has been ample evidence that a rational juror could find that they conspired to commit at least a pattern of racketeering activity. And obviously, defense counsel has focused on the money or proceeds. The state believes that for purposes of directed verdict, the easier one to start with which is count 12 of the indictment, and the 3 criminal objectives as the court outlined in our proposed
12.
page 12 of the indictment, Your Honor.
All right.
That focus on murder, aggravated assault, acts of violence, as well as intimidation of law enforcement and witnesses, which is, I give them numbers in terms of the order of the bullet points. I believe that that's the easier argument or more efficient, because there's...
Right. I mean, if the state has alleged 2 different ways of the defendants having violated RICO through a RICO conspiracy, and y'all only have to prove one. You don't have to prove both.
Correct,
So
Your Honor.
you're saying there's at least evidence as to the overall purposes, Part B of RICO.
Correct, Your Honor. And a couple things is in terms of that objective of racketeering activity, specifically the murder and the aggravated assaults. You have, from the defendant's own words, and tattoos, their allegiance to YSL. And I don't want to cite a litany of cases, but there's a number of factors that courts use to establish an enterprise. For example, United States v. Harris, 695 F. 3rd 1125 1136 is a 10th Circuit 2012 case, is display of colors. jewelry, clothing, all of those are just 3 to start. You also have tattoos, which are permanent. And so Mr. Kendricks has slat on his left forearm and a large snake that was introduced, I believe yesterday or day before, on his stomach that goes up to his neck. You have defendant Stillwell, who has multiple admitted exhibits in post that reference slime or reference his, for example, Exhibit 430 VV is defendant Kendrick, overt act 133 with a red bandana and a YSL pendant. State's Exhibit 511 VV, as admitted, is overt act 138, is defendant Kendrick with a hat with a rat crossed out on it. State's Exhibit 38, November, is overt act 134, where you have Kendrick pointing at the cameraman, 2 individuals with Make America Slime Again. And I could go on, but the point being, you have both 2015 exhibits where Detective Gaither and Detective Dennis, you had Twitters of Mr. Sledge, you had Twitters of Mr. Zachary, Twitters of defendant Stillwell, where multiple, and I'll give a few examples that actively and openly possess my slimes, YSL, this is my brew. And that allegiance, coupled with the evidence at trial of the murder of Donovan Thomas to begin with, which captures overt acts 16 through 20, which the evidence of that murder from the interview statement of Kenneth Copeland on June 10th, 2015, and Quindarius Zachary on August 15th, 2015. Quindarius Zachary's interview, which was played for the jury and is in evidence, states that defendant Kendrick and Stillwell confessed to him that very night. And defendant Williams' condo, who rented the Hertz rental vehicle that the Infinity rep, Mr. Thomas Burnett, stated from watching the surveillance video, which I believe is 296 Yankee, that Detective Teague with APD introduced, that was an Infinity Q50. All of those things combined, that statement of Copeland and Zachary for the why it is a criminal enterprise murder. There's no personal disagreement between Mr. Thomas, Mr. Kendrick, Mr. Stillwell. It is that rivalry of a criminal street gang that weaves through this case. And so in terms of commonalities, it is similar offenses, whether it's victims, the method and mode of operating. In this case specifically, you have a number of incidents that involve multiple YSL, self-identified or APD gang detective identified members committing acts of violence together. In Donovan Thomas, you have 4. In Shamel Drinks, you have 4, at least defendant Stillwell, Mr. Garlington in the white Audi, defendant Nichols and Miles Farley in the white Ford Fusion. On the April 28th, 2015, which was Demekion Garlington getting jumped at Club Crucial, there's a 911 call around 2 o'clock a.m. Fast forward, you have 2 shootings at 1903 Drew Drive and 1428 Adele. You had testimony from Ms. Bell, whose home was shot, crime scene technicians and responding officers, and you had in the interview and testimony of Zachary and Sledge, that act in concert, which was only 3 months after the murder of Donovan Thomas, shooting at, intending to strike rival opposition members, the ABG, Inglewood family, YFN, that group. So from January 10th, 2015 to March 14th, 2022 of the murder of Shamel Drinks, the targeted acts of violence in concert by YSL members is towards the same opposition group. And that's significant for multiple reasons, because as the court knows in RICO, evidence can have multiple relevant purposes to both prove the criminal enterprise and also prove the pattern of racketeering. And I think what is important in this case is, although the state did not allege subsection alpha or bravo of the RICO statute, actual commission of racketeering activity gives clarity that this conspiracy was not some fanciful idea. It was actually alive and well. The best evidence of a conspiracy in a group is a decade's worth of similar victims, methods of operating, and public an active allegiance to this YSL enterprise afterwards that this case and the evidence through testimony and exhibits has established. So the courts, or the state, as a number of other factors, and I will not rattle off all of these cases that are other factors the court looks to an enterprise, gang and hand signs. There's been evidence admitted in testimony from APD gang detectives of the quintessential YSL hand sign, the wiping of the nose, greeting phrases the court has heard and seen in text messages and wiretaps, slat and slime.
Why don't you move on beyond
Yes.
enterprise to some of the other necessary elements?
Yes, Your Honor. So does the court have a specific necessary element that the court would like to hear?
Well, what were you going to talk about next?
Fair enough, Your Honor. So to give structure, moving on from the enterprise, when in terms of agreement or the defendants agreeing to be a part of this, the state's argument, and again, the evidence can have multiple relevant purposes, the tattoos and the public, both association with YSL members and active promotion through either of that criminal street gang through their own words or social media of showing allegiance to that, posting with YSL pennants, using the common gang identifiers and hand signs and with other YSL members throughout from 2015 to as recently as 2022 shows, and the commission of the racketeering activity shows that they were a part of it. As in, you do not need, of course, a written contract. You do not need, of course, some videotaped roundtable of discussion. Their actions speak louder than words. And so if you need to, there's ample evidence a rational juror could find that because of the commission of murder, aggravated assault, and continued association, that they have actively agreed to be a part of this enterprise through their very own actions. You also have October 1st, 2015, where Martinez Arnold gets jumped at Magic City by Kelvin Watts, Shell Kel, who of course has been talked about this week in relation to March of 2022, which shows a commonality. And then he calls Mr. Kendrick, who rides with him, where they get stopped with the multiple firearms in the Trestle Tree area, which there's been testimony from Detective Griffin, who was the lead detective on the Tierra Jones homicide. There's been detectives from multiple APD gang detectives about where Summerhill or ABG in that area is where their territory, so to speak. So that action, the January 10th, 2015 murder of Donovan Thomas, however many months later you get to October 1st alone, shows a commitment and an agreement by your very actions, willing to either assist or actively participate in racketeering activity. Furthermore, Your Honor, of course, I think the easiest of this, one overt act committed, and of course one committed within 5 years of the indictment. The state has, I will use because it's, I believe, one of the most readily assailant overt acts is the murder of Shamel Drinks, which the state believes through the testimony of Iverito, the social media introduced, is a rational juror of fact would find that to be street gang related, enterprise related. Again, there is no evidence of anything other than association with a rival gang that is in evidence of why Shamel Drinks would be murdered for going to pump up his car with gas. And so that act is certainly, it's only a few months before the indictment itself. That alone, the state believes there's been ample evidence that defendant Stillwell has committed that act along with other YSL members, and that alone, a rational juror could find happened and was for, going back to page 12 of the indictment, one of the overlying purposes that the state has alleged, which is important, of preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder. When YSL members were murdered on March 11th, retaliation was needed for the enterprise's reputation and to exact vengeance. And so that overt act alone satisfies. Of course, there is ample overt acts alleged of promoting either the gang itself or violence. I didn't want to run off a litany of admitted exhibits with.
Okay, how about
Yes, Your Honor.
are you going to talk about what the pattern of interrelated racketeering activity within 4 years of?
So, Your Honor, yes, I will take the testimony that has came out related to YFN Lucci or Mr. Bennett, and that is a perfect example of, you have, when Mr. Sumlin testified and the call was presented of Christian Eppinger, who was in the jail, calling him saying, I'm on PC with that boy Lucci, how much can I get for that? Then you have the text messages that were the color-coded charts that Viverito walked through with Khalif Adams, Demekion Garlington, and Jaden Myrick. Then you have the video that from the jail where Jaden Myrick, after that messages about stabbing YFN Lucci, through the testimony of Viverito of what they were discussing, actively tried to stab YFN Lucci. Then you have the post of defendant Kendrick predating that, but 2019, I believe, standing on top of YFN Lucci's.
All right, but I mean, a post isn't an act of racketeering, so talk about.
Yes, Your Honor. So you have multiple YSL gang members, all of which, I use that example because I believe it's so salient, of multiple actors, multiple ages, multiple years in time. It's the same individual that they're trying to exact violence on, who happens to be the same individual who was very close with Donovan Thomas from 2015. All of those, that pattern, the victim and the method of operation, using other YSL gang members,
All right,
create.
so which acts of racketeering activity are interrelated that have to do with that?
Yes, Your Honor. So specifically, you have let me grab my indictment, Your Honor, so I can see
Sure.
the accurate numbers. Thank you, Mr. Floyd. So in terms of overt act numbers, you have Act 171 as the Eppinger and Sumlin conspiracy to commit murder, which was the jail call, which has been introduced. You have overt acts 165 through 167 is Bobby Hunt, Khalif Adams, Demekion Garlington, Scarface, and Jaden Myrick, which is all related to that February 9th, 2022 attempted murder of Mr. Rayshawn Bennett. And you also have, this is not an overt act, but is quite relevant for this purpose, States Exhibit 227VVB2 is the text message from defendant Stillwell's phone where he says, on February 9th at 7:31 p.m., which is, I believe, within 30 minutes of that stabbing, they just wet Lucci's BITCH ASS up, which again shows an us, a them, a concert, an agreement, a pattern, a method of utilizing contacts through jail, prison, or on the streets to concoct a plan and enact violence on a rival gang, specifically a rival gang leader, who, of course, on January 22nd, 2015 and January 26th, 2015, mother's house was shot at 1007 Hill Street. You also have the overt act that is in evidence related to the post from defendant Williams of, if I didn't like what you did for your kids and your mother, I would have been killed you, which was about Mr. Rashawn Bennett, YFN Lucci. And so all of those things combined without, you have words in the text messages through somewhat coded language. You have jail calls where Christian Eppinger does mention his name, but you have where they all know what they're talking about, what the goal is. They don't need to go into the agreement and the enterprise's objectives morph into one and the same in terms of they don't even, they all have the same common goal of enacting violence on a rival opposition. Is the conspiracy that could be a possibility when I actively join this enterprise is best proven by the attempted murder, and the pattern of racketeering proves the conspiracy was alive and well, in this case for upwards of a decade. And all of those, of course, I use because they're more recent. They're well within the 5 years. Your Honor, I also believe that in terms of an overall pattern, when you have, of the 28 defendants indicted, there's many connections in terms of Rodelius Ryan was, I believe, 15 when the murder of Jamari Holmes happened. Roughly, the murder happened early that morning around 4 o'clock. Later on that day, he posted a video of, I bet YSL makes the news. He has Instagram messages that are in where he alleges is quite actively stating FUCKYFN, ABG, right? He would have been 11 years old when Donovan Thomas was murdered. When Wooney Lee testifies about, we put that, on your gravestone, he would have been much younger. He doesn't come up his name in the murder of Donovan Thomas, but the fact that members who either have, actively promoted, tattooed, claim allegiance to this enterprise of different ages, of different times, have the same enemy, the same disagreement through racketeering activity in its truest sense of violence, is the similarity, is certainly for a rational trier of fact to find that there is a clear, common, interwoven theme, which I use the violence because, again, I believe it's the most salient of this point for purposes of directed verdict.
All right, can you speak to whether it matters that the indictment itself doesn't contain the language willingly and knowingly, willfully and knowingly?
So, Your Honor, Mr. Floyd was going to address that much more eloquently than I.
That's fine.
If that's all right, but with the court.
Okay, thank you, I appreciate it.
Yes, Your Honor. Yep.
And you're going to do that for the RICO and the gang counts, the language?
Yes, Your Honor.
Mr. Floyd, okay.
Here's the swab. Thank you. That's what I needed. Yes, sir. Okay. Your Honor, first, what was characterized, I think, as a general demur argument, or an argument that included general demur.
Right.
I listened to it and it was very familiar. It was very familiar because it was made and rejected over 2 years ago in the same case. The Ruan case to which reference was made is a United States Supreme Court case. It is not a RICO case. It is nothing like a RICO case. It was a case that involved the federal prosecution under the Federal Controlled Substances Act of doctors who had basically signed pill mill prescriptions, and the application of a federal regulation to that circumstance dealing with the validity of those prescriptions. So not on all fours, not on all threes, maybe not even on all twos. The important thing that matters is the statute. First of all, the text of the statute does not make reference to knowingly and willfully. And so the charge is in the language of the statute, which is sufficient. I mean, that's pretty much the end. That's pretty much the end of that argument. To the extent that the argument blurred into kind of a special demur argument, the point is that first, every defendant is charged with conspiracy. There's no question about who's charged and who's not. It's very clear. It's charged in the language of the statute. Every defendant is alleged to have actually committed acts of racketeering activity. Those require a certain level of intent, and that is proof of the level of intent sufficient to commit a racketeering activity has been, active racketeering activity has been held sufficient to sustain a RICO conviction by the Georgia courts. They've said there isn't another layer above that. If you have the intent to commit the act and you commit the act, that's sufficient. Page 60, most of this is laid out on page 12, but also of the indictment, but also if you go to page 68, which is at the end of the overt acts, you'll see that we have specifically alleged they were committed in furtherance of the conspiracy, tying every act to that conspiracy, and therefore every individual who committed one of those overt acts to a conspiratorial agreement alleged above that they had the same or similar, which is the test under the statute for relationship. Similar is sufficient. Intents, results, accomplices, victims, or methods of commission, or otherwise were interrelated by distinguishing characteristics. I think Mr. Adkins has well covered that component of it, but it is also specifically alleged here.
Okay, that's page 67 of the indictment.
68.
67 of mine.
Oh, okay, sorry. You probably have the you have the deluxe version. At any rate, it immediately follows the last predicate act, so that'll help us all navigate. The point though is that, and this is as true of the Gang Act as it is of this. The cases that have said knowingly and willfully, or the cases that talk about what has to be proven, are not pleading cases. They're not general demurrer cases. It's just a question of what does the state have to come forward with. Neither statute says knowingly and willfully. Rodriguez is familiar to me. I briefed Rodriguez. Mr. Carlson and I argued Rodriguez. Rodriguez was a facial constitutional challenge. It had nothing to do with the sufficiency of pleadings. And it simply interpreted the statute in light of a vagueness challenge. So not close to being on all fours with this situation. There is no Georgia case of which I am aware that says the state has to allege knowingly and willfully. It's purely a question of proof. That takes us to the directed verdict standard, which is simply, could a rational juror find that these defendants acted knowingly and willfully? Most of the argument on that was simply the defense's interpretation of the meaning and weight of the evidence, which is not a permissible consideration in this analysis. The court does not resolve, cannot resolve those issues. And for a case that's directly on point on that, that is the Evans case, which I believe I cited to you yesterday. It's the other APS appeal along with Cotman, and it lays out the standard in the specific context of a directed verdict or motion in a RICO conspiracy case. And the standard that it enunciates is exactly the same
I
as.
think you cited that yesterday. Can you give
Okay,
me
I'm
that
sorry.
slide?
It's Evans v. State. By recollection, it's a 2019 decision. I don't have it immediately in front of me, but there's only going to be one Evans RICO APS. There it is. It is 360 Georgia Appeals 596 at 600. The court said the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And thank you. And just since I'm up, the question of, I guess I'd call it the more than one overt act being alleged, more than the jury seeing more than one overt act. I mean, the logic behind that is kind of topsy-turvy. If you think about it, there's nothing that requires the state to plead the barest minimum in an indictment. And in fact, generally to do so, we would draw a wave of special demurrers. Even with this indictment, we drew special demurrers with as much detail as it has.
At this point, they're not any longer challenging what you put in the indictment. They're saying whether it's in there or not, it shouldn't be out with the jury for their consideration.
Well, that comes down that comes down to if I understand correctly, an argument that there's not sufficient evidence for the jury to find the defendants acted knowingly and willfully, and that is clearly present.
Oh, no. I think we're interweaving
I'm sorry,
different
then,
issues now. I thought you were moving on to the issue of whether overt acts that aren't within the 5 years,
and
whether it was-
indeed I
Yes,
have.
it was definitely okay to put them in the indictment, whether they should go out with the
Yeah,
jury.
okay, I understand.
If you weren't, then bring me back to what
No,
we
I
were
may have,
talking
I may have
about.
ground the gears a little bit on that
Okay.
one. But I think, I just want to make sure you don't have any more questions about the knowingly and willfully issue. And if you don't, then I'll move on to that question.
Okay.
If I understand the logic chain from the defense, it is basically, we only have to prove one overt act within 5 years of the date of the indictment. Therefore, anything else is, I think the term was used, surplusage. That doesn't fit the definition of surplusage. And then with particular emphasis, they've said if it's outside of that 5-year window and then would not be relevant to prove the timeliness of the indictment, that then particularly the jury shouldn't hear it because it's confusing, et cetera. I'm aware of no case that has accepted that argument, and it shouldn't be accepted because the allegations are relevant. They show the existence of the enterprise, right? This is, this begins, it begins a long time ago. The state is not precluded from charging or presenting evidence that shows this enterprise has existed for a long time. I mean, at the kind of the extreme level of this, there are federal RICO indictments involving the 5 families in New York that discuss the entire history and formation of them, going back to the Castle Amorisi War of 1932, I think it is. So they would now span almost a century. That was not irrelevant because it tells you how this enterprise came to be, and it shows the early participation of certain individuals. It shows its longevity, its consistency. I mean, under the law, enterprises don't have to be in operation 24 hours a day. They can have lulls, et cetera. But where they continue to exist, where the people who participate in them continue to acknowledge their existence, that is certainly relevant. And there's not an arbitrary cutoff where the indictment gets trimmed to match the statute of limitations. I'm just not personally aware of any case that's ever done that.
Okay.
Thank you.
May I respond briefly?
Well, I mean, we're still in the middle of the state's presentation, so yes, y'all both get, since it's your motion, a chance to reply, but not right now.
Good morning, Your Honor. I'll be addressing the directed verdicts as to counts 2 and 49 of the indictment, which are the murder counts. Count 50, 51, and 57, which are the participation in criminal street gang activity. Counts Mr. Floyd, whenever the court's pleasure, will address the general demur as to the participation in criminal street gang activity.
I mean, Mr. Floyd, did you have anything, I mean, I took your argument to be essentially, the knowingly and willfully as it applies to RICO, and then basically apply the same argument with regard to the in furtherance of the gang, with regard to the gang counts. Did you have anything to add to that?
Not really, Your Honor. The statutes are quite similar on this point. Historically, the Gang Act is actually kind of a linear descendant of RICO, that some states didn't want to enact a full RICO. They just enacted a gang statute. We enacted both. They have slightly different elements, but on this principle, there's really no difference.
Thank you.
Thank you.
And then I'll be addressing count 62, possession of a machine gun. And then count 52, 64, and 63, which are the possession of firearms by a convicted felon.
All right, 52 isn't the 133, right?
No, Your Honor. 133 will be count
63 and 64.
63 and 64, Your Honor. So, Your Honor, as Mr. Floyd just enumerated, the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt, and that's cited in Evans v. State, 360 Georgia Appeals 596, which is a 2021 decision. And first, we're going to start with count 2, the murder of Donovan Thomas Jr., Your Honor. The state has presented evidence that we believe will be sufficient for a rational trier of fact to review in the light most favorable to the prosecution. Your Honor, we have presented evidence of the June 10th, 2015 video recorded interview of Mr. Kenneth Copeland at the Atlanta Police Department, which is Exhibit 378, Yankee Echo. In that video, Your Honor, Mr. Copeland discusses a co-conspirator statement of Deamonte Garlington, in which Deamonte Garlington tells him about the murder of Donovan Thomas, that who was involved, which was Mr. Stillwell, Mr. Kendrick, Mr. Justin Cobb, Mr. Damas, and Mr. Damas McMullen. In that interview, Mr. Copeland speaks of his whereabouts on the day of the murder of Donovan Thomas, beginning on early in the morning hours, and when he eventually meets up with Mr. Garlington at a gas station on Cleveland Avenue. He further tells the detectives that Mr. Garlington told him that those 4 individuals, again, Mr. Stillwell, Mr. Kendrick, Mr. Cobb, and Mr. McMullen, had committed the homicide of Donovan Thomas Jr. He told them about the type of car that they were in, which was an Infiniti vehicle, the location of where Mr. Donovan Thomas was, which was the barbershop on 330 McDaniel Street. We then also introduced the August 2015 statement of Quindarius Zachary, which was State's Exhibit 531Y, which Mr. Zachary corroborated some of the same information that Kenneth Copeland provided. He also added the additional information or evidence in that interview, which was Mr. Stillwell and Mr. Kendrick at the condo of Jeffery Williams confessed to him that they had participated in the murder of Donovan Thomas Jr. Those statements and the details of those statements are corroborated by certain other evidence that has been admitted. We have the barbershop surveillance video, which is at 292 Yankee Alpha through 292 Yankee Delta. That video surveillance showed Mr. Donovan Thomas Jr. outside the barbershop moments before a silver and color vehicle, which was identified in testimony as an Infiniti, drove down the street and shot several rounds of gunfire at and towards the direction of Mr. Donovan Thomas Jr. We also have the Texaco surveillance video, which corroborated Mr. Kenneth Copeland's statement. In his statement, Mr. Copeland tells officers that Deamonte Garlington told him that they met at the Texaco gas station, that they switched cars, which he explained that Mr. Kendrick initially arrived in a Pontiac Bonneville, and that the gray Infiniti vehicle met at the Texaco gas station. That was depicted on the surveillance video. In the surveillance video, you see Mr. Kendrick walk into the gas station. You see Mr. Kendrick approach the vehicle, approach a silver Infiniti vehicle. You see both of those vehicles leave out of that gas station at the same time. Your Honor, yes, what we do not see is when the transition occurred between Mr. Kendrick getting out of the Bonneville and getting into the Infiniti, but we believe there's a reasonable inference that happened off camera outside of, we believe, behind the Texaco gas station. Mr. Copeland also discussed in that interview that the car that they used was rented by Mr. Jeffery Williams. We were able to admit State's Exhibit 334Y, which was the rental agreement from Hertz Rental, which showed that the vehicle was rented by Mr. Williams about 2 days before the homicide of Mr. Donovan Thomas Jr. We then also have phone records that corroborated what Mr. Copeland said. We have the phone records that showed that when Mr. Copeland woke up in the morning hours, or the afternoon hours, excuse me, of January 10th, 2015, he was located, he told police he was at his girlfriend's home, which was in the village of Carver Homes. The phone records corroborated that his phone was at that location at that time. He then proceeded to tell officers that from leaving his girlfriend's house, he went to the green store. The phone records corroborated him going to the green store. The phone records then corroborated what he told police, that he then went to the McDonald's gas station, the McDonald's restaurant, and that's where he met with Deamonte Garlington, and that's when Deamonte Garlington explained to him everything that occurred. Mr. Copeland was also able to tell the police that Mr. Demise McMullen actually was at the McDonald's when he arrived, or when he met with Mr. Garlington. The phone records corroborate that Mr. McMullen actually made contact with Mr. Williams about 6 minutes after the murder of Donovan Thomas. Immediately following the phone call with Mr. McMullen, there is a number of different phone calls to a variety of different people, specifically an individual by the name of Kelvin Treadwell, O.G. Bentley. Both Mr. Copeland and Mr. Zachary, in their statements, advised that after the murder of Donovan Thomas, that the guns in the vehicle were given to Kelvin Treadwell, also known as O.G. Bentley. The phone records corroborate that a number of different phones, Mr. Williams' phone, Mr. McMullen's phone, all ping in the location in and around near Kelvin Treadwell's home after the murder. Their phones ping off of the tower closest to Mr. Treadwell's home. So that evidence has come in, Your Honor. We have the autopsy photos that show that Mr. Donovan Thomas was murdered and killed with certain types of shell casings. Your Honor, we have the jail call of Mr. Stillwell. I do not have that exhibit number, which was entered after his preliminary hearing, Your Honor, in which at the preliminary hearing, we know from both Investigator Thorpe and Deputy District Attorney Michael Sprinkle that during the preliminary hearing itself, they didn't use any names. They used witness number 1, witness number 2. However, on the jail calls that we have both with Antonio Sledge and Mr. Stillwell, that they identified one of the witnesses being Little D. Little D was the nickname for Quindarius Zachary. And what Mr. Stillwell said during that call is, they snitched on me. And I'm paraphrasing. It was never, they lied on me. There was never any other language, but we have that evidence. We have that in evidence. We also have in evidence, Your Honor, State's Exhibit 477NN, which is the slat talk video in which Mr. Stillwell says the words, "I just beat a murder rap, pay my lawyer $30 for that." Also, he has we introduced more recently another song that Mr. Stillwell has, which was called BS or Bullshit. And in that song, he says, "Beat the hom, no evidence." We believe that is another reference to the murder of Donovan Thomas. We also have State's Exhibit 436VV, which is Mr. Stillwell after, in 2019, posting a picture with himself in a slime sweatshirt with the peanut gravestone in Spanish, then immediately deleting that from that Instagram post within a few minutes after posting it, Your Honor. So we believe that there is sufficient evidence for the jury for a rational trier of fact to be able to find the essential elements of the crime beyond a reasonable doubt. Next, Your Honor, I will go to count 49, the other murder count in this indictment, Your Honor. Your Honor, the state has admitted crime scene photos of the crime scene at the time. That's going to be State's Exhibit 65, Victor Victor, through 115, Victor Victor, specifically 79, Victor Victor has Mr. Shamel Drinks deceased inside of the car.
We definitely know he's dead.
Yes, inside of the car. We then have, Your Honor, the surveillance videos from, specifically, I'm going to focus on the BP surveillance video, which is State's Exhibit 116 BV, and the FedEx surveillance video, which is State's Exhibit 117 BV. In both those videos, Your Honor, initially, before we know who was identified, we see a white, extremely darkly tinted Audi vehicle come to the gas station. We also see a white Ford Fusion. We see individuals from those two vehicles enter into the gas station. We later learn that that is both Shannon Stillwell, Quarmavius Nichols, and Miles Farley. We have the evidence that in that same surveillance video, within 5 to 7 minutes after they are at the location, Mr. Drinks arrives at their location in his red vehicle. He is seen walking inside of the store. That surveillance video then shows that when Mr. Drinks' red vehicle leaves, very soon thereafter, both the white Audi that's tinted leaves the location, as well as the white Ford Fusion. We do have a wiretap telephone call, which is State's Exhibit 437 VV. The call, I can't recall the page number at this time, Your Honor, but the call that is at 9:59 p.m. based upon the wiretap data, which is a call that tells from Deamonte Garlington telling another occupant of the white Ford Fusion to immediately get on FaceTime, Your Honor. There's evidence from even Mr. Deamonte Garlington's wiretap where they talk about getting on FaceTime when they don't want to discuss certain things on the phone. We also heard that from expert witnesses that FaceTime is a mechanism that is used when criminal activity is going to take a foot because it cannot be tracked. At 9:59, that call takes place. We then see on the FedEx surveillance video at approximately 10:01 p.m., Mr. Drinks arrives at the lights, as well as the white Audi, as well as the white Ford Fusion. The white Audi and the Ford Fusion stay at the light for approximately 2 minutes, Your Honor, before they take off into traffic running the red lights. Your Honor, at that time, the red vehicle never moves again. We see from the ankle monitor records, Your Honor, based on the evidence that was provided in the ankle monitor records, that within a minute, Mr. Stillwell's ankle monitor goes from 18 miles per hour to 90 miles per hour. We know from the phone records that both cars travel in the same direction towards Fulton Industrial Boulevard, where we believe they go to a music studio. We then have from Mr. Stillwell's phone a phone note in which, I'll paraphrase, he talks about dropping the ops. Very soon thereafter, and that is right after Mr. Drinks is at that light. We then have, Your Honor, again, phone records that put both Mr. Stillwell, Mr. Farley, Mr. Nichols all in the same area, which is the area of the gas station in and around the same time. Your Honor, we have social media posts. Oftentimes we don't have motive, but we have social media posts in this case that were posted between March 11th, 2022 and March 15th, 2022. One, we know that on March 11th, 2022, the evidence showed that 2 YSL associates were murdered on a highway, both Mr. Christian McMillan and Mr. Darius Ford. And we have in evidence State's Exhibit 452 VV, which is a post from Mr. Stillwell, and I believe this post is on March 11th or maybe March 12th, that says, "Just rest, Mac, I got you." Then we also have a post, which is 458 VV, that is posted on March 11th with Mr. Stillwell posting, "I ain't gonna be the only one crying." Then on March 15th, 2022, we have Scarface, who is, we believe, in the car with Mr. Stillwell at the time that the murder takes place, posting, a picture of both Mr. McMiller and Mr. Ford saying, "We got y'all boys." And that is only hours after the death and murder of Mr. Shamel Drinks. We then also introduced, Your Honor, the rental car agreement, which showed that Mr. Stillwell rented this vehicle on March 14th, 2022. And then we also have the wiretap information that shows that he went to a tinted window car place and got deep tinted tints on this car on the day that this occurs, Your Honor. And then we have text messages while in January of 2022 saying that he goes op hunting. So, Your Honor, we believe that that evidence is, quote the right language, that evidence is evidence that a rational trier of fact could find the essential elements of the crime of murder beyond a reasonable doubt. Next, Your Honor, I will go to count 50 and 51, which are both the participation in criminal street gang activity as to Mr. Shannon Stillwell, and then count 57 as to Mr. Deamonte Kendrick. Mr. Atkins touched on this somewhat, but I'll just add some additional evidence that has been presented. We have the testimony from investigator Mark Belknap, Trontavia Stevens, Walter Murphy, Antonio Sledge. Well, sometimes it was easy to get out, sometimes it wasn't, but they all have said that YSL is a gang. We have evidence of the tattoos of Mr. Kendrick, which was 518 VV to 520 VV, which—
Before you do the gang counts, can
Yes.
you address the 58 through 61 drugs and machine gun, and whether there's evidence of constructive possession for Mr. Kendrick?
Yes, Your Honor. So first with the possession of machine gun, which is count
62,
62.
yes, sorry.
One, just the proof that of the gun itself, we have the—
I know that that's established.
Okay, so as regarding Mr. Kendrick, Your Honor, there is evidence that we know from his phone that he had been at the home earlier that day. We know that based on testimony from Officer Samba, that he fled from the home
No, he was, okay.
and apprehended, Your Honor, and we believe that that would be some evidence of consciousness of guilt, the fact that he fled before the police even, I think, hit the door of the home, that he had fled out of the home, Your Honor. We believe that inside of the home, there were a number of guns, both from the pictures, you can see that there's a number of guns outside on the kitchen table. There were some guns.
Remind me where the machine gun was found?
The machine gun is actually downstairs, we believe, in the basement of the home by underneath
Lay
the
it on the
couch.
floor?
Yes, laying on
Yeah,
the floor
okay.
underneath the couch, Your Honor. It is the state's theory, Your Honor, that when the SWAT team did not make a quiet announcement to get to come into the home, and it is the state's theory that when the announcement was made, you could tell from some of the images, we believe that there was an effort to hide some of the items that were inside of the home. This gun was kind of maybe kicked underneath the couch where you had to pull it looks like they pulled the couch back in order to observe this gun that was actually in the basement, Your Honor. To address the drugs, Your Honor, which are counts 58 through 60, which is the possession of marijuana with intent to distribute, the possession of codeine, and the possession of cocaine, Your Honor. I believe all of these items, which was Stacy Exhibit 12XX, 17XX, and 18XX, the marijuana, I believe, was out in the open. If my memory serves me correct, I need to pull up the picture again, but I believe that the marijuana was out, present, and open in the home, Your Honor. That specifically 18XX was not hidden. 17XX was the marijuana with guns that was found in a cabinet, I believe above the refrigerator inside of the kitchen of the home. And then the codeine, if you give me a moment, I just want to pull up the picture so I can make sure I know where the codeine was found
They
inside.
were like in a box in a closet, right?
I believe they were, but I thought that there was some that was out as well. But of course, indulgence. Yes, Your Honor, the codeine was found in the closet and then in the bathroom upstairs in the house. And then the cocaine was found in the pantry as well. In that same bag, there was a bag that had in the pantry that had the cocaine and the cocaine and the codeine, Your Honor.
And the marijuana was out where, in the kitchen?
So there's one in a Tupperware container that's in the, on the kitchen counter, and then there's the bag of marijuana that was in that cabinet with the gun
Right.
that's in the cabinet above the, I think, the refrigerator.
Was there any evidence presented that Mr. Kendrick was like staying there as a residence, or just that he was there that day?
No, Your Honor, the evidence that we have is that he was present that day, and we believe that he had been present maybe a few days before.
But not continuously?
Not continuously, no, Your Honor.
And so can you address constructive possession?
Your Honor, it's just the state's position that at the time of Mr. Kendrick being at the home, that he had knowledge of the drugs being present in the home, Your Honor. Specifically the marijuana, Your Honor, as well as the guns being in and around the home.
He's only charged with a machine gun, right?
He's charged with the machine gun, and he's charged with possession of a firearm during a commission of felony with all the other guns that were found inside of the home, Your Honor. So he's charged both.
That's the count.
That's-
Which count is that?
Yes, Your Honor.
That's count 63.
Yeah, so count 62 is the machine gun, and count 63 is possession of firearm by convicted felon for the other, in addition to the machine gun, the other guns found inside.
Where are all of those found? Remind me if you don't mind.
Yeah, they're found in different locations. So I believe the FNH 57, I don't, so 13XX, Your Honor, the FNH 57, and that's found on the kitchen counter behind like a green dinosaur. And then there's the two firearms.
Can you
which is-
show me a picture of that? Let me join Zoom.
I'm logging into the Zoom now.
Yeah, I am too.
So, Your Honor, this is, I believe, the FNH 57, I think it's 57. And that's in the living room area.
All right, those are just sitting out on the counter, right?
Yes.
All right.
And then
That's in the cabinet.
that's the
above, yeah.
Yes, Your Honor,
So a lot of this looks like it's documenting what the guns are. I just want to see the ones that show where they were found.
So these are two more.
Those are in the cabinet.
Those are in the cabinet.
Above, yeah.
This is the pantry, Your Honor, where this other gun was found.
That's like I think somebody referred to it as like the hidden
Yes. It's
door or something like that.
Yes, Your Honor.
And that's where the codeine's found too?
Yes, Your Honor.
And the cocaine?
Yes.
Okay.
And then this is where the machine gun is found, Your Honor.
That's after the couch is moved or after it's,
Yes, Your Honor.
any idea where, do we have a picture of the couch before it was moved?
No, I don't think so, Your Honor. I think once they moved it and found it, they took a picture of it.
Okay. All right, thanks.
You're welcome.
All right, and then you were going to circle back to,
Your Honor, I guess there's one more gun to be shown.
okay.
And there's one found in the upstairs bedroom.
Whose bedroom is that?
We believe this is, the room. We think that the ID for Jimmy Winfrey was found in this room.
For who?
Jimmy Winfrey was found
Okay.
in this room.
All right.
Go back to the gang count, Your Honor?
Yes.
Okay.
And address Mr. Kendrick's count first, which is 57.
Your Honor, it's the state's position, Your Honor, that the drugs inside of the home were all, specifically the possession, the codeine, Your Honor, as well as the marijuana with the phone counters were being prepared for distribution. If you remember, there was the large pail of codeine that was found, a number of different bottles being found, Your Honor. As you also saw, although not charged because it's not illegal, was the YSL drink juice that was inside of the home, Your Honor, which looked like that was being packaged for some type of sale or distribution of itself, Your Honor, that these particular drugs were possessed in furtherance of the criminal street gang to sell narcotics, Your Honor, to sell both marijuana as well as to sell the codeine. We have evidence of the money counter inside of the home, Your Honor. Mr. Kendrick was at the home, was present at the home. There are a number of different guns present inside of the home, which we know guns are usually kept with drugs in the sale of drugs, Your Honor. And so based on that evidence, we believe that there's sufficient evidence to go back to the jury to show, at least for that count, participation in criminal street gang activity, given that evidence that has been admitted into evidence, Your Honor. Court's indulgence.
We didn't have any evidence as to like the weight of the cocaine or anything like that, did we?
Yes, I believe the GBI did.
Okay, maybe y'all just didn't highlight that.
Yes.
But that wasn't a,
That's not an intent to
that wasn't a
distribute.
distribution
No,
amount.
no,
Okay,
that's
right.
simple
All right.
possession. And Your Honor, it's specifically regarding the guns, because we also charged count 57 with the guns. the state believes that they were still in the midst of a gang war. This was only 2 months after both Mr. McMiller and Mr. Ford had been murdered. There had now been the retaliatory shooting of Mr. Shamel Drinks. We know that 2830 Waters Road had been shot at multiple times. And so we are now still in the midst of, or we believe, a gang war. And with that amount of guns and weapons inside of the home, a machine gun, Your Honor, that these were tools, whether it was to protect themselves or get ready to go and continue war, that they had this ample amount of firearms inside of the home, all in furtherance of this gang war that we believe is still going on even to this day, Your Honor.
All right, moving on to Mr. Stillwell's other counts.
Yes, I believe Mr. Stillwell's count that I have not addressed yet are participation in gang activity, which I believe Mr.
Yeah, save that one to last. Let's talk about the underlying ones first, if you don't mind.
So I believe his next count is possession of a firearm by a convicted felon and possession of a firearm during the commission of a felony, Your Honor. I believe those are the last two.
Okay, hang on then. So,
And I will address the possession of a firearm during the commission of a felony, and then Mr. Abati will address the 133 possession of a firearm by a convicted felon.
give me a second. I'm sorry, they're kind of not all together in the indictment. I
No
wanna make
problem,
sure
Your Honor.
of. All right. Go ahead.
Okay, so for count 54, Your Honor, possession of a firearm during the commission of a felony, Mr. Drinks was killed with, I believe, a 40 caliber, I believe, a Glock handgun based upon the GBI testimony that came in. Your Honor, there was testimony yesterday from Investigator Viverito that in a video that's was created about an hour before the murder of Donovan Thomas, that there is a gun that could be consistent with a Glock 27, which is a 40 caliber handgun. That is the evidence that we have, Your Honor. We never recovered the handgun used in this case, Your Honor, but there is evidence, I believe if we look back to the Donovan Thomas murder, that after that murder, they got rid of the gun. It's the state's theory that the same thing occurred in this case, that after the murder of Mr. Drinks, that they did get rid of the Glock handgun that murdered Mr. Thomas. But we do know that he was, excuse me, Mr. Drinks, but we do know he was killed. It is the state's theory that Mr. Stillwell shot and killed him, and would have shot and killed him with a .40 caliber handgun, Your Honor.
All right, and then the other gun one was the one that was tossed or that.
Yes, Your Honor, did we
tossed
know from Miss,
Right before they were arrested.
right before that, I'm sorry, that's count 60,
Okay, that was registered to,
Miss Taisha Alexander, Your Honor.
all right.
And I do believe for the gang, Your Honor, Mr. Adkins discussed that within the RICO when he talked about
Okay.
the gang. So
Thank you.
thank you, Your Honor.
All right, reply, argument.
I don't feel the need to go on and on, but Your Honor, I just wanted to clarify one thing. I felt that there was kind of a straw man where my argument was being presented about the overt acts alleged, that I didn't, the state needs to give a history, and the jury needs to hear about the history of different acts. I'm not saying that those overt acts aren't relevant, and obviously, we've been in here for a year. They've presented evidence of those overt acts, many of them, not all of them. My assertion and my argument is merely that the state should not be allowed to create an indictment with alleged overt acts that are outside the statute of limitations, and then a listing of those overt acts goes back to the jury as part of the indictment. And that's all I'm arguing with that. Not that it's irrelevant, not that they can't get into it, because
Yeah,
obviously they
I
have.
understood that to be your argument. I appreciate that. Thank you.
Your Honor, the state stood up here and gave a very thorough response to our motion for a directed verdict. But they never once, and I was listening very carefully, and you specifically asked them about the constructive possession. They never once made argument regarding any intent shown by Mr. Kendrick on possession of those drugs or guns. They made some arguments perhaps about ability, although even that I think was somewhat strained, where you have firearms that are in cabinets and closets and wherever, and he's just a guest in the home. The issue of intent is one, again, that you're going to instruct the jury on in the jury instructions. You also have a mere presence that you're going to instruct the jury on. So Mr. Kendrick, while he may have been present in the home, there hasn't been any evidence regarding intent, Your Honor.
All right, why don't we take, I don't know if lunch is here yet, but why don't we take a break for a little while? Y'all can see if you can get together and come to whatever agreement you're going to come to on overt acts that there hasn't been evidence presented on. And I want to read the motion that got filed and look at some of the case law and maybe review some of the evidence. And then, presuming I don't grant the motion on every count, which I think maybe there's been some acknowledgement that at least a tiny bit of one count might be able to go forward. We need to finish the charge conference. You were going to say something, Mr. Sharp?
I was just going to let Your Honor know that I did. Calling it a chart is really giving it way too much credit. But I did email that to Ms. Persfield and the state, and I will update it after I confer with the state and figure out.
I didn't mean to oversell what we had put together last night.
It's fine.
One other thing, as far as the charge conference goes, I did submit one additional proposed jury instruction to
I
Ms.
saw that
Percival.
one. I'll be interested to hear your argument on that
Thank you.
and the state's response.
Yes, Your Honor, and on that note, we have discussed the charges for the overt acts that the jury would not otherwise be instructed on, like armed robbery. I just want to let the court and defense know that the state has and is about to submit to
Okay.
the court and parties the underlying crimes of the
Okay.
overt acts that are crimes and not otherwise alleged.
All right, thank you.
Your Honor, when it's appropriate, it can be later but could the lawyers from each side approach about a scheduling matter?
Y'all can do that now. Work together again, everybody at lunch, and we'll reconvene here at 1. And I'll give y'all my ruling on the motion for directed verdicts, motions for directed verdict, and we can do whatever else needs to be done with regard to the charge conference. However, I guess on the do y'all mind doing the overt act thing and then getting that to me and then going to lunch so that I can have that with me? Okay, thank y'all. First, with regard to the ruling on the motions for directed verdict. So both the state and the defense requested and have gotten a trial in this case before a jury. Is not before the court as a bench trial. So that means that this court is not the trier of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution, and doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged. So with regard to the motion for directed verdict on counts 1, 2, trying to do these in order. Well, let me just do it this way. I am denying the motion for directed verdict on all counts except I am granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. And let me say that with regard to counts 1, I'm sorry, not count 1, counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments, but it is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it in evaluating this, I have to believe, I have to evaluate it as though the jury is going to believe whatever is most beneficial at this point to the state's case. Which means they could believe everything that Mr. Copeland or Mr. Zachary said that would support the state's case. And frankly, they can disbelieve even an expert's testimony. And so I just wanted to add a little more with regard to what my reasoning was as to those counts. So that's, y'all know now what it is that you need to be preparing for closings. And I think unless there's anything else on those matters, that we can turn to the hammering out the rest of the jury charges and sorting out the verdict form. And I appreciate that y'all seem to have been able to determine for a lot of the overt acts, which there is not any evidence of, and so obviously those will get redacted out of the indictment. Oh, let me also say with regard to those gun charges that we talked about earlier, that I am granting a directed verdict with regard to the greater of those charges on the 133. The state even admits they don't have all of the elements for that. So those will be charged as the lesser. It looks like that Martinez case provides that even over a defense objection, the state is entitled to get the lesser charge for those counts. So that's why that's kind of, I guess, a grant of a partial directed verdict as to those counts. And those were the Well, y'all know which ones they were. I don't have them right, right in front of me. What were they?
52, 64, and 61.
Okay, thank you. All right. So I haven't yet seen the proposed charges on the crimes that are set forth in the overt acts. So, Mr. Atkins, we did get, there were some additions or changes with regard to the state's proposed RICO instructions, but have you sent yet the crimes that are just set forth in the overt acts?
The pattern instructions, Your Honor?
Yeah.
Yes.
Okay, maybe we just missed that.
I titled it, Your Honor, proposed, I think, supplemental jury instructions.
All right, well, Ms. Persfield will look for that. I know there are a couple of things we need to circle back on the non-RICO part of the jury instructions, but let's do the RICO part first, if you don't mind. And I keep further editing my proposed RICO jury instructions, so y'all have the latest, I'm not going to say greatest because it may not be, but the latest version of what the court is thinking about charging. So if we want to open that up and kind of start there, and then I'll listen to whatever anybody wants to suggest should be in or out or said differently. Now, Mr. Atkins, I wasn't quite sure I understood your teal. I didn't know if you were saying, oh, the court struck through these and we think they should be included, or what exactly the teal comments were.
Your Honor, the teal, I tried to capture either items the state believed
Okay.
should come out
All right.
or words that the state had.
Okay, so we maybe just, as we walk through, you just bring them up to me as we get there. All right, so if we want to all get to that document.
Mr. Floyd is going to take the lead
Okay.
on this part.
And, Your Honor, since you just emailed us, is it all right if I remain seated because then I can see
That's fine.
the screen? And
Yeah.
are we going to go through what the state emailed to you first, or are we going to go through what you just?
What we're going to go through is what I am proposing, and then to the extent that y'all want to add or subtract or modify, y'all tell me. So I can open up as well. I've got multiple screens up here. The state's latest proposals as they modified them, and then the defenses as well. I think those are the same as they were a couple of days ago.
Okay. Well, Your Honor, since we had submitted those, I can go through those and explain what our thinking was.
Okay.
And the first one is, I'm going off of.
Let me find it first, if you don't
Excuse me,
mind.
Mr. Floyd, which document are you referring to?
I think it's something Mr. Atkins sent us. Is that right? Last
Oh, last night.
One we said last night, yes.
Can you give me just?
Yeah.
It's called Jury Instructions RICO Draft is what the reline for the email is. And then it's got an attachment.
Thank you.
Councilman, do you have it?
I have it.
Okay, I didn't want to.
No, thank you.
I think there's another one.
No, that's not RICO, that's the one.
I'm assuming the one you're referring to is the one. It came around 8:20 last night. Oh my gosh.
Talking about, no.
Which one?
There's 3 documents. The court's version of the RICO charges, the one that Mr. Atkins sent last night, that was jury and, no. Sorry. That was the jury instructions RICO draft for Mr. Atkins. And then there is also, more recently from Mr. Atkins, the additional instructions that relate to some of the overt acts.
That's correct, Mr.
Okay. All right.
And so, as I understand it, we're going to talk about the state's RICO instructions that Mr. Atkins sent last night.
Sure.
At approximately 8:20, that's the one? Okay, thank you.
That sounds that time sounds right. It certainly felt like about 8:20.
I felt like midnight.
And it's got yellow and red and teal and it's multicolored. That's
It's,
the one
it's,
that's supposed to be.
it's a potpourri, Your Honor. Most of these, despite the color variations, it's pretty simple, I think. The first one that the state proposed some changes to state RICO conspiracy, and I noted that the court had said needs to be tailored to indictment language.
Uh-huh.
I took that.
That was really early on.
Okay, well, but I think it was correct too, because what was there prior to any modification is just a recitation of the statutory language or something very, very close to it.
All right. So if you would do me a favor and looking at the state's proposal, do you feel like that captures everything that needs to get captured?
I think it does.
Okay.
And what we were looking to do is just remove language that is in the statute.
Right.
That does not
Agreed.
apply to this case as it's been charged and presented.
Okay, so,
It just simplifies it. That's
yeah, so I mean, what I'm proposing is the state must prove that the defendant, and then list out the elements, knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the conspirators committed an overt act to further a criminal objective of the conspiracy. So I think that gets rid of all of what was not applicable from the statutory language.
I think that's correct, Your Honor.
Okay. And then, you know, a similar thing for the subsection B.
Yeah, the only, we've been using the word tweak. In the language that tracks subsection A,
Yeah.
3, personal property, money or other personal property, this may just be semantic. I think the statute actually says personal property including money, which includes money, but this starts with money. The statute starts with personal property. It encompasses money. It's not a big deal.
Yes. Money is personal property, which is why it says money or other personal property. Okay.
And as to the elements of B, yes, I think you captured that as well.
Okay.
Your Honor,
Yes.
regarding this, I just had one issue as well. I didn't know
Sure.
before we moved on, are you done with?
I'm done with this, John.
Okay. Your Honor, I would ask on number 6
Yep.
of the elements,
Mm-hmm.
since, well, I don't know, I haven't abandoned my argument, but if we're gonna allow all the whole list of overt acts on the indictment to go back to the jury, I would ask.
Well, not the ones that y'all decided there's no evidence of.
Right, but the ones outside the statute of
Yeah.
limitations, I would ask that, on number 6, it's committed an overt act on or after May 10, 2017, or
True.
within the
True.
Yeah, the only thing I'd point out is you've got that later.
I do.
And so, I mean, I agree it has to be somewhere. The question is where.
Well, I mean, the idea with listing out the elements is when they're deliberating, they can go right to that and go, all right, here's what we need to be thinking about. So,
Which is why I think Mr. Schart's suggested edit is useful.
so I had written down the dates. It's like between May
It'd be May 10th.
10th of 2017 and May 9th of 2022.
No, it would be within 5 years of the date of the indictment.
No, but let's
Right,
give them the dates.
why not just give them the date? Why make them do math?
Yeah.
All right.
Nobody wants to do math here, we're all lawyers.
The calendar in my head wasn't functioning properly.
Yeah, I mean, the indictment, the original indictment was what, May 9th? Okay, so,
If that captures that 5-year window, we have no argument.
okay,
But the indictment doesn't, the indictment says, said accused together with unindicted co-conspirators in the state of Georgia and county of Fulton. You mind if I said?
go ahead.
On or between the 24th day of January 2013 and the 8th day of May 2022. So maybe the cutoff
Okay.
date should be the 8th day
So
of
then
May.
what would that be? May,
May 8th, 2022.
no, for the beginning, May 9th, 2017?
It would be May 9th, 2017. No,
I do too, May 10th. I don't think they're,
May 9th.
and May 8th, and honestly, the dates don't, and I'm saying May 9th, 2022.
Your Honor,
Yes,
the evidence demonstrates the conspiracy continuing after that. The evidence that's been admitted demonstrates the conspiracy continued after that. That's
so what's the law on, is it within 5 years before the indictment, or is it within 5 years before the indictment?
it's before the indictment is what the cases say. I mean, if you look at, I believe it's Conzo,
But
that's the case. And
continuing on up until the jury gets the evidence.
yes.
Well, I would disagree with that just because it's specifically pled
yeah.
in the indictment. It says, in the RICO charge, it says, for the said accused together with unindicted co-conspirators in the state of Georgia and County of Fulton, on or between 24th day of January 2013 and the 8th day of May 2020.
Yeah, and with that specific date in there, I would think that anything after the 8th day of May 2022 should not be considered.
Thoughts?
Yes, Your Honor. The fact of the matter is that we did not allege that the conspiracy ended, was terminated, or abandoned. And the jury can look to subsequent acts as evidence as well. I mean, up to and including, for example, Mr. Copeland's testimony. If the jury concludes that Mr. Copeland was lying and that was in furtherance of the conspiracy, they could consider that. The case on that is State v. Cagno, C-A-G-N-O, 978 Atlantic 2nd, 921. It's a New Jersey 2009 appellate case which involved the untruthful testimony of a witness during an actual trial. And the court looked to that and said that where that witness was part of a criminal organization and the evidence indicated that he was lying to protect the criminal organization or any of its members, that could be considered even though it ran all the way up.
Do you have any idea how that case was indicted? Like what the language of that, if that,
In truth, Your Honor, I have not seen the indictment. It would have been indicted under New Jersey law in any event. So,
right?
I mean, that is, you know, I understand your question, but I think, I don't think there's any question that there is evidence presented and admitted in this case that runs past those dates.
Well, the state certainly could have elected to indict it in that type of fashion with language that's a little more open-ended, but the notice that we were given by this indictment and that they elected to put in here, we didn't pick this date, is the 8th day of May of 2022.
And additionally, beyond it being cut off by the 8th day of 2022, it's our stance that any overt act that the jury's going to consider has to be pled in the indictment. And so they don't have any overt acts extending beyond that date.
Your Honor,
Yep.
I'm sorry, but I have to disagree with Mr. Sharp. The state's not obligated to plead any overt act specifically in the indictment.
Right.
That's simply not a requirement. And therefore, the fact that there isn't one after the 8th specifically alleged, although we do in the superseding, we have the 9th there. They have notice of that. Okay.
They do.
Acts 183 and 183 through 189, the dates are given on those acts, and they are May 9th.
Yeah, Mr. Floyd is exactly right. They do have acts that are specifically listed in the indictment on May the 9th. But despite that, they still chose to put May the 8th in as the timing of the conspiracy. And it's the same way that they have overt acts that predate the statute of limitations that they've placed in there. I'm sure they have good reason for that. But you know, they could have additional things in there. So again, they're the ones that elected to place May 8th as the end date.
If I may just jump in, I'm under the belief, and maybe I'm wrong, Your Honor has granted a directed verdict for the May 9th.
Not all of it, some of it, but not all of it.
Those overt acts would be coming out of.
No, because Mr. Kendrick, I mean, if they determined there was a conspiracy and there were other conspirators, even if Mr. Kendrick wasn't the one guilty of any of these, somebody who might be a conspirator could have been. All right, so I don't think that most of the times dates in indictments aren't material anyway. So I would think it's between May 10th, 2017 and May 9th, 2022. And I need to, that's all of the overt acts that are pled. So you're saying overt acts that aren't pled can support the conviction,
Yes.
if there is to be one, as long as they are within, 5 years after the indictment?
There's no
There's
time limit
no-
afterwards. I mean,
It's
there's
just,
just overt acts.
Yeah.
And I understand why the defense desires to put a box around this, but the law doesn't put a box around this in the way that they are suggesting it. In fact, you might recall, Your Honor, a few months ago, we submitted a bench brief on this.
yeah,
And we showed you cases where convictions were affirmed based on overt acts that did not appear anywhere in the indictment. I mean, there just has to be an overt act. Overt act is really
yeah.
evidence. That's really what it comes down to. So here, this evidence is in.
I just don't see how, and I understand conceptually, but how does the jury say, okay, here's the overt act that we're all agreeing was proven, but it's just something we heard in the evidence that how do we even know, how are we supposed to know what that is?
Well, as a general matter, I think, I'm trying to think of the best way to synthesize this. Again, it's evidence. They just have to determine that there was an overt act. And that
they all agreed to it.
That they all agreed to it. And, I mean, there's a million aspects of evidence in here. Actually, in a case this long, a million might not really be hyperbole. that they're going to look at, but we're not going to ask them, do they find that this car was the same, this gun was the same? We don't walk them through the inventory of evidence, exhibit by exhibit, and say, did you find this persuasive or not?
Yeah.
That's not.
All right, so can y'all come up with some language that succinctly and non-confusingly says had to happen by, the, earliest, May 10th, 2017? That just makes it really awkward.
I just also
So I
need
don't know how to say that exactly.
I just also need to clarify that I'm not trying to put the state into a box. I mean, this is a box of the state's own construction that they've crawled inside by setting this May 8th termination date, May 8th of 2022.
Maybe I should have called it a mini house. Anyway, I understand. Okay, Your Honor, the relevance of this, as far as I've understood it, is that they are finding an overt act within 5 years of the date of the indictment, because that's necessary for limitations purposes.
Right.
That's the pertinent question. And I believe you previously had a charge that explained that. If I don't see it in these court charges, excuse me. Yeah, I don't see it exactly in those. The ones that the state had submitted, I believe there is one on it there. But the only concern I have, and it's not a huge one, is that as to item 6 on these two, you're going to be saying the same thing twice.
What do you mean?
Not a big problem.
What do you mean?
Commit an overt act and then the date. Commit an overt act after the date that is 5 years prior to the indictment. You would say it twice there instead of once in a statute of limitations related charge. That's all.
I don't know what you mean.
I'm sorry?
I don't know what you mean.
I thought what we were talking about, and I apologize if I've lost the path here, in item 6 is committing an overt act, and the request was after a specific date. That would place the overt act within 5 years of the indictment. Okay. And I'm just suggesting you could say that once in one charge that's related to statute of limitations, or you could say it twice in each of number 6 because they're identical. Committed an overt act.
All right, where's your statute of limitations language in the state's proposed instructions? Because I don't see it.
I apologize. Neither do I.
Okay, didn't think so.
There was, I'm thinking one, I know I've seen one, I guess it wasn't in this version. But the state does not disagree that an instruction that says the jury has to find an overt act within 5 years of the indictment is appropriate. That's fine. We're not disagreeing with it. It's simply how the exact language is crafted and where you place it in this sequence.
Well, I think it's probably easy enough to say committed and as number 6 to both of these, committed an overt act after May 10th, 2017.
Okay?
I would suggest, Your Honor, that, it's the law. So I think we definitely want to make the jurors aware of the law as they're judging this case, and the correct law. I keep going back, we're giving them a long list of overt acts, and as lawyers in this courtroom, we're fully acknowledging that many of them, based on the date, cannot be that overt act. And we will not be back there to explain it to them, so I think we need
Well, we can explain it to them before we send them back then.
Well, right, and I think we need, my point is, with the jury instructions, I think we need to make that very
So we might
clear.
want to add something. Many of the overt acts
Well, I was saying,
listed occurred before.
Mr. Floyd seems to want to
Alleged.
just say it once and make us pick. What I'm suggesting is we say commit an overt act, and then if we want to say within the applicable statute of limitations, and then
I'm not going to say that. That tells the jury nothing. I am going to say committed an overt act after May 10th, 2017, and I'm going to say it right in that list.
okay,
Isn't that what you were asking anyway? I mean, I know you wanted a,
it's
close brackets at the end of it,
that
but
is absolutely what I'm asking. But in your charges,
Mm-hmm.
I think it's important that we put it there. But in the court's proposed charges, you also have a separate charge about the statute of limitations for overt acts. I'm pretty sure I saw that in your.
oh, that was,
That was in the one that you sent a couple of days ago.
don't look at that. Look at the one that Ms. Parsfield sent to y'all about 10 minutes ago.
The one you sent today, it's in the second to last paragraph highlighted in
Yeah.
yellow.
And yeah,
Unfortunately, I made my edits on the one that was
well,
sent,
that's
so
fine.
I'm trying
That's
to,
fine.
Yeah, I'm trying to go back and forth between.
But I agree with Mr. Shart that it doesn't only need to be in there one time, and if your goal
Yeah.
of the initial,
It's not going to be in there just one time. And the language that's kind of at the bottom of the court's proposed RICO instruction right now, I mean, I'm thinking that it may be that those sort of paragraph language for count one and then the 4 or 5 paragraphs after that, that's going to be after all of the instructions when, we always say, you'll have a verdict form. I think this verdict form may be one that I actually hand out to them and say, and walk them through, and then kind of say, all right, look, here's how you're going to think about this. And I am going to tell them when you're filling out the verdict form, because right now, at least, I'm thinking I'm going to have them list the overt acts that they unanimously agree to.
yeah, I think that would be best, Your
And
Honors.
that I'm going to say during that part, at least one of these, to support a conviction, at least one would need to be after May 10th, 2017.
Yeah, I think that would be the best way to go, and especially because of how, even for attorneys, how complex this is.
Yeah.
That if you could walk them through that form in that fashion, that would be beneficial for all involved.
Your Honor.
Yes.
Just because this argument seems to have shifted a little bit, looking at the first page of the most recently distributed
Yes.
court's charges, simply adding after May 10, 2017 to number 6, each time you've got it, because you got it there twice, without any objection.
Okay.
That's fine.
All right.
Getting into the details of the statute of limitations as it may fit into the verdict form, I don't think you want to do that here.
I'm
because
not
it
going to.
interrupts the flow of the elements.
Agreed.
And then when we get to the verdict form, I have a point about what's.
That would be
discussed.
greed, because
I can do it now, or I can do it
don't do
later
it
when
now.
you want.
Don't do it now.
Okay, all right.
All
I
right.
will not do it now.
Next.
All right. Under conspiracy, the last sentence, it may also be inferred from any evidence.
Where are you?
Last sentence. Last
On the
full sentence.
states proposed? Where are
I'm
you?
following this personal.
Okay.
I'm
I don't,
Okay, the charge begins with the bold
Yes.
conspiracy.
yes.
The second paragraph under that, which
Okay.
on my printout is the bottom.
Okay, yes.
All right, in the last line, it says after the commission of the alleged offense.
Yes, that is highlighted because that was the language that was proposed by somebody, and I don't know what that's supposed to mean. So what do y'all mean by that?
I don't know that this is what we proposed, but it
I
may
don't
have
know
been-
where it
may
came
have been
from.
picked up from language in other kinds of conspiracy cases. But I think here you could say the alleged overt act as opposed to offense, because some of them are offenses and some of them aren't.
I mean, I would imagine it was the state that proposed this.
It
I
may
mean, we
be,
could,
but I
just to be
understand it
less
could-
confusing, just say presence, companionship, and conduct.
That's fine. And then we don't have to give it the temporal reference.
So, well, I don't know that we need to say it at all, because we've already said the nature of any acts done, the relationships, which would be companionship, conduct of the alleged conspirators, which would be conduct.
And so are
So
you
maybe
looking-
just ditch that sentence altogether.
And stop at criminal design?
So it would read, the existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. Moving on?
If I could have just a second.
All right.
Moving on, Your Honor.
Okay.
On second page, overt act.
So obviously, I'm not going to include in there the two sources. I just wanted to let y'all know that's where I got the definition of overt act.
I understand, and I didn't think that was going to be in there. But the modifiers open or manifest, I don't think that's necessary, and I think it tends to be confusing because they're going to be left to kind of guess at what open and manifest is. An overt act can actually be inaction.
We looked at the case law that y'all cited in support of that, and we don't read the case law to say that. It was supposedly in Pasha.
Pasha says that a single overt act is sufficient. Yes.
Doesn't say it can be a passive non-act act.
Right. But
So where's that?
My main point is it doesn't say open or manifest, and I can't remember.
I'm trying to define overt act.
Right.
And there is a definition of overt act in the Bradford case, and maybe that was a conspiracy case, and that's why I cited 1648.
My only point here, Your Honor, is that I have never seen that language used in a Georgia RICO conspiracy case.
Okay, well, do you have a definition of overt act? Because nobody knows what an overt act is. And to define overt act as an act in furtherance of the conspiracy doesn't define overt act. I mean, I'd love a definition.
All right, Your Honor, if we can have the opportunity to take a look at it, and we may be able to submit something that does that work. I'm just concerned about open or manifest. They aren't self-defining terms. I don't think they actually.
If they don't help, then yeah, I don't want to use them if they don't help.
I'll just, if you give us an opportunity,
Sure.
we'll look, and if we can find something that we think contributes to clarity, we'll certainly send it to the court promptly.
There's the Black's Law definition.
That's actually the place I was thinking of looking. Generally, jury charges, I looked at a lot of jury charges in connection with this and other cases, and I've really not seen this kind of language open manifest. I can't say that no court has ever used it. There's so many conspiracy cases out there. I'm just saying that I don't
Well,
remember
here's
in connection with.
an act that can be observed. I don't know that I can access blacks on here. It's probably a paywall.
I can, once we've finished here, and I can check on that.
Laura, I know I've got an older blacks in chambers. Do you mind running to get it? I doubt if they've changed the definition that much in the last few years.
You probably haven't changed it since Blackstone died.
Correct. All right, anyway, we'll come back to that.
Okay, also on page 2, the next thing the state had was the last line, which is just the modifying language naturally or necessarily done to further the unlawful enterprise. I think done to further the unlawful enterprise is sufficient. And I'm not sure that naturally or necessarily adds to that.
Well, naturally might not, but I think something in the way of a modifier, because it's something that should not encompass, something conspirator X does that is just this random thing that might, but is not designed to further anything. I think is and we didn't make that language up. It came from some case.
Okay.
Sorry.
I understand. If it was just random, it wouldn't be done to further the enterprise. That's why I think done to further the enterprise captures what's necessary. The language in the statute is to effect the objectives of the conspiracy. There's no naturally or necessarily. And
I think it might have even been from a U.S. Supreme Court case, but we'll ask Ms. Persfield when she gets back.
there's quite a few of those.
Any weigh-in from the defense on this?
I'm sorry, Your Honor. I have 3 different versions of very similar documents.
I am so sorry. I know.
It's okay. Mr., if you could tell me, I got to
read it loud if that helps.
Well,
It's the bottom of page 2 of 5, the last paragraph in a document titled Judge Draft RICO Charge that we
They're
received.
all titled that, unfortunately.
I'm sorry?
I think they're
They're all
titled
labeled that. Rev 3, maybe it should have said.
It says, when people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be the act of all of the conspirators. However, each conspirator is responsible for the acts of other co-conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise.
I'm not sure about the need for naturally, but I believe that necessarily is an important word there.
I'm going to disagree with my colleague.
We'll figure out the source of that language and come back to that as well.
May I go? I'm just going to try to jump in sequentially.
Okay.
So we can
Yeah.
go down this.
Yes, that works.
If I could go to the paragraph above that.
Mm-hmm.
No. Okay. 3 paragraphs above it.
To be an enterprise?
Here.
What's it say?
Here, the specific enterprise the state alleges is young sod.
Oh, yeah.
I'm going to ask Your Honor to consider just taking that out. We're defining enterprise. I don't think we need to make specific reference to the state's allegations.
Fine with me. They can read it in the indictment.
They can read it in the indictment and we can argue it.
Okay, it's gone.
And then I'm going to object to, there's a paragraph, 2 paragraphs down from that, in determining whether an enterprise existed.
Yes.
I don't think we need anything after the racketeering activity, comma. I think it can say, in determining whether an enterprise exists, you may consider any evidence of a pattern of interrelated racketeering activity. Period, that's it. I don't think we need it, and such evidence may be sufficient for you to.
Yeah, that came from, I don't know,
Came from Turquette versus United States.
Yeah.
And Boyle versus United States. Straight out of Supreme Court language, and it's out of Martin versus State, which is Georgia Court of Appeals, adopting Turquette.
yeah. It is confusing though.
Well,
I mean, it's like almost saying the same thing twice. I think the first time it's saying consider it, and then the second time it's saying it could be enough.
yeah, I think you, to simplify it, if that's the objective, we might just say, determining whether an enterprise existed, you may consider any evidence of racketeering activity. Just stop there.
Oh, no, it needs to say a pattern of interrelated racketeering.
Well, it doesn't need to say a pattern and interrelated, so I can just say a pattern of racketeering activity, because when we defined it, it has to be interrelated.
And
Well, then if that's the case, could we leave in interrelated and get rid of pattern? If you only want one of those words,
Sure.
I prefer
I'm
interrelated.
fine with both of them.
Well, I am too, and that's my preference.
this is, the concern I have, Your Honor, is we're drifting into the elements of 1614(4)(b) and not C, because the state technically doesn't have to prove a pattern.
Well, it's not saying you do. It's saying you can consider any evidence that there might be.
I see. All right, fair enough.
Okay, in determining whether an enterprise existed, you may consider any evidence of a pattern of a pattern of racketeering activity.
I think just a pattern of racketeering activity. You're going to define
Yeah.
that term
All right.
elsewhere.
We've got the Black's Law Dictionary now.
Drum roll.
We definitely, the first one is not applicable. Number 1, an act that indicates an intent to kill or seriously harm another person and thus gives a person a justification to use self-defense. That one is not applicable. Number 2, an outward act, however innocent in itself, done in furtherance of a conspiracy, treason, or criminal attempt. So an outward act, I mean, it's a, okay.
I think
See actus reus, also termed positive act.
Outward act might
I think outward
work.
is closer. Positive is easily misconstrued.
Yeah.
by
Positive is
lawyers.
confusing.
I mean,
yeah.
I think the word manifest was like, it's something that's actually done. But whether that's a helpful word for the jury is another story. Let me just pull up Bradford real fast. All right, so this is Bradford v. State, Supreme Court, 285 Georgia 1 from 2009. An overt act is one commonly understood to be, quote, open, quote, manifest, or, quote, public, and that is citing Black's Law Dictionary. I think that's just the definition of, I don't know, it's a different Black's Law Dictionary than I have right now, but open, manifest, or public from Black's Law Dictionary, 1990. Mine's probably newer than that.
Yeah, the most recent one is,
Mine's not the most recent one. It's probably from law school, but
all right, it's the best one.
It's the 7th edition, the one that I have in front of me right now.
I think we may have agreement that outward does the job. I think the fewer words that are used here, the better.
I think manifest can be confusing to a
Okay.
non-lawyer. So I'm okay with outward,
Outward.
unless Max disagrees with me again.
I don't know what manifest means.
So outward, yeah, outward is good.
Outward. Okay. Means an outward act. Made in furtherance of a conspiracy. Okay. Thank y'all for your help on that.
I don't know if we made it any better, Your Honor.
All right, now back to the naturally and necessarily. Ms. Persfield, do you remember what case that language came from? The under enterprise, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally and necessarily done to further the unlawful enterprise. Okay, we'll get back to y'all. Mr. Floyd, it's from the jury instructions from the APS case, which you touted to be the standard by which we should all be
I
measured.
think I did.
So I think
mention
we're
that
gonna-
Things have evolved a bit since then.
I think we'll be leaving that in there.
All right.
Thank you, Ms. Persfield.
My plan is to not die on that hill. On page 3, Your Honor, definition of racketeering activity, the first line. I don't think or soliciting someone else.
Yeah, that's why it's
highlighted.
highlighted,
commit.
so that was where the teal stuff got confusing. I didn't know whether the state wanted that in or out.
I think we can take it out.
So
What
it's
we were,
just
what we were
committing or
trying to
attempting
do
to
is
commit.
simplify it by not having you instruct on things that aren't.
Well, I don't believe there's any allegation or any evidence of solicitation of someone else.
Yeah, I don't either. Okay, so that would then just read, means committing or attempting to commit any of these crimes in the list. All right, under the list, I think the states had use of an item with an altered identification mark. Do we have evidence of that?
Yes, Your Honor, it was the Trontavious Stevens had a firearm with a scratched off serial number.
Okay.
That, I think that evidence came in through an officer
All
testifying
right.
about it.
I thought so. I just wanted to circle back on that one. And then all of your other teal things, again, I didn't know whether that meant
I
take
apologize.
these out, leave these in.
I apologize, Your Honor, for the teal confusion, but my intent was to,
Well, let me ask you this. If you look at the list as it exists in this draft, does that cover?
it does, Your Honor, and I actually, the burglary,
Right.
we do not need, that there was an
Okay.
allegation of a burglary on an overt act that we did not present evidence
All
of.
right, we'll take that one out.
What about use of an item with an altered identification?
Yeah, we just talked about that one.
Okay, I'm sorry.
And Mr. Atkins is right, there was some evidence of that introduced.
Okay.
The possession or the use of?
The reason we put that, let me explain that changer. Okay, sorry. Is that some of the drug-related offenses are broader than mere possession or use. And so we put possession or use in there because that's possession and possession of with intent to distribute. That's what's charged.
Where are we talking about?
We are in the list of crimes, the last two.
Okay. Possession of marijuana with intent to distribute and possession of marijuana?
Right.
Okay,
And I think we meant to make this modification with related to controlled substances. It may not have gotten in there. But the same thing, possession of controlled substances, possession of controlled substances with intent to distribute.
okay, so right now it's violation of the Georgia Controlled Substances Act. Do we want to,
We can,
Article 2, and I assume that both codeine and cocaine are within Article 2 of, okay.
Schedule, cocaine's a Schedule 2, codeine's a Schedule 2 or 3, by memory. Yeah.
So then it would be what? Possession of codeine with intent to distribute is what was charged, right?
Yes, I believe so. I mean, the language about Article 2, that comes from the actual language of the statute.
Right.
That's written for lawyers, that's not.
Right, no, I agree, I just,
Yeah.
okay, possession of codeine with intent to distribute, possession of marijuana with intent to distribute,
And then we have
possession of cocaine, and possession of marijuana. Okay. And then I still need, we're going to have the definition of murder anyway, and of the, we won't have the, I still need the definitions for all of these, the pattern language definitions.
Mr. Atkins, can you submit that?
Yes, Your Honor.
Okay, all right.
I'm not the runner.
Okay, moving on to pattern of racketeering activity.
If I, you know, one
Yep.
other thing.
Sorry.
Based on your ruling, possession of marijuana could come out, your directed verdict argument, verdict ruling.
Nope.
No, because there's code.
It's a,
It's still over, sorry, my mistake.
I'm sure the
I agree
defense
with
would be
Mr.
happy
Floyd.
to have it out.
I agree with
but-
Mr. Floyd, they can come out.
Yep. I think he misspoke on that.
Do the current charges on the table have this second paragraph with about the threats? That I'm looking at.
Is it under racketeering activity or something else?
Well, I mean, right, under we have racketeering activity,
Uh-huh.
and we define it, and then we have a second racketeering activity.
Right.
Also means any act or
Right.
threat.
Okay, I don't know. Do we have a threat that involves murder, robbery, theft, receiving stolen property, obstruction of justice, or dealing in narcotic or dangerous drugs?
We're gonna bring them homicide. Yes, for the caption of one of the photos. Yes, we do have, we have threats and we have acts.
Okay,
So, I mean, the any act or threat involving language comes directly out of the statute.
Okay, but we don't have a threat of robbery, theft. I don't even know what a threat of dealing in narcotics or dangerous drugs would be.
by God, I'm going to deal in narcotics.
We don't have a threat of obstruction of the officer. I don't know what a threat of receiving stolen property would be. So why don't we just say, and take what I would suggest, we just take that threat paragraph out, and we could just put murder or threat of murder.
Well, and then you would have what? Any act involving for the.
Any
remaining-
act that involves murder, threat of murder, robbery, theft, et cetera, et cetera.
I think that could do it, yes.
Okay. Thank you.
Great with that, thank you.
Okay. I'm actually changing it online. What else? So that takes us to pattern of racketeering activity, although we definitely need the definition of the underlying crimes somewhere.
Your Honor, going back just a second.
Okay.
On the reference to controlled substances on page 3, the two specific drugs would be cocaine and codeine, possession with intent to distribute.
Okay, so what I've done is just like we listed the specific other things, I've got possession of codeine with intent to distribute, possession of marijuana with intent to distribute, possession of cocaine, possession of marijuana. Does that work? Okay.
All right, thank you. All right, we did not, I don't think we tealed up page 4, which would take us to page 5.
All right, are there any issues for the defense on pattern of racketeering activity?
Yes.
Okay. And I've even got an issue on what I list as my element number 3. When it's only a conspiracy, there don't have to have been racketeering acts achieved. There might be, but there don't have to be. And so how do we deal with they've got to be within 4 years of each other?
I don't think it's relevant here, because the question is the contemplated objective, not the actual way it turned out, because that would be a substantive charge. I don't think there aren't any that are separated by more than 4 years.
Well, I mean, y'all were just arguing we've got the murder of Donovan Thomas in 2015, and then we have the murder of Mr. Drinks in 2022, right, which is more than 4 years. And so assume that's all that they find is interrelated. Then what?
Those would be the acts that actually occurred, okay? And in a substantive case, that would be an issue, right? But this is where we get into this whole problem of exactly what was everybody contemplating exactly every moment in time in a case like RICO that tends to unfold over time. And so, Shamel, specifically, let's kill Shamel Drinks might not have been in everybody's mind 4 years before. At some point, it came into.
But if they contemplated
Killing opponents.
Let's kill not just the leader, but the leader and everybody else we see.
Kill the cat and all the kittens as the.
Then does it even matter? Does the 4 years not matter then?
4 years does not matter in that circumstance. And there's certainly no Georgia case that says it does.
Well, are there any Georgia cases that deal with conspiracy assertions and not substantive that also talk about this?
Provision?
Yes. To me, this is the toughest issue there is in terms of figuring out what the actual law to charge is.
I understand the challenge, Your Honor, but again, the one thing that when you look at the cases that address conspiracy is that while there are aspects of conspiracy and substantive charges that are similar and maybe even overlapping in some respects, conspiracy is different.
Yes.
And so what this is basically importing the what ultimately happened test in here. I'll go back to the hypothetical, and I'll try and.
Well, I mean, I understand your hypotheticals. What I'm going from is the statute, which is what the law actually is, unless, further developed by case law.
I mean, the question is whether the conspiracy contemplates a pattern of racketeering activity. And if that pattern could take place within 4 years, like that would be sufficient.
Right.
And we can't say that everything that actually happened had to fit that.
But how do we explain that?
It's not a conspiracy case anymore.
to the jury.
Now,
I mean, I don't think this needs to be mentioned to the jury, but if the court believes it does, the way to do it would be, I think, to say that they considered engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of, and not make this a separate thing at the end.
well, so, Your Honor, on page 4 of, I think it's on both your drafts, you have an instruction, and I took liberty to propose some changes, so it might not be exactly how it is in your draft, but it says the state must prove, I added beyond a reasonable doubt.
Yeah.
that defendant-
I'm telling them that all of this is beyond a reasonable doubt. None of the pattern charges that have been changed say that every time, so.
Okay. And it says that defendant, and I took the liberty to say knowingly and willfully, agreed to join a conspiracy with the knowledge and
Okay,
intent.
are we back up at, I'm trying to figure out where I should go.
Mr. Short has jumped down to below the line of asterisks where it says
Okay.
4 count 1.
Okay,
But I think that this charge may be what we're essentially
okay,
talking
go ahead.
about.
I
The
just
state
wanted
must
to know
prove
where to,
the defendant,
Uh-huh.
I added knowingly and willfully,
Okay.
agreed to join
Yeah, that
a
needs to be-
conspiracy.
with
with
the knowledge and
intent
intent is
that-
knowing and willingly, I think.
Okay. Yes, Your Honor, that one or more conspirators would commit at least 2 interrelated acts of racketeering activity, and then I think we're saying within 4 years of each other. And it seems like that charge would go to under where we're just previously talking.
Okay.
So we'd move that up, it seems to me.
And, Your Honor, I was not clear from this whether the section that begins on page 4 and is under the asterisks, whether this is something you were intending to speak to the jury about in connection with a verdict form, or whether this is part of the instruction.
Yeah, I don't know. I mean, it's part of the instruction. I think it needs to get said. Whether it gets said here or whether it gets said when I get to the verdict form, I hadn't decided yet. I just think this stuff needs to get said. So I don't know the answer.
Okay, here's my concern is
Yes.
that to the extent you're restating elements that
Yeah.
have been stated before, they're being restated in different language.
Right.
And that can be a source of confusion. I mean, the court, the way I was interpreting what the court did at the beginning of these instructions is you tried to make these as short and succinct and simple as you could, consistent with the language of the statute, and I understand that. But here we're kind of restating the same premise, but with different words. I don't know which set of words the jury's going to follow. That's my concern.
I mean, as long as they're not inconsistent words, it doesn't matter. If they just further flesh something out, that's fine. So if you think they're inconsistent, point that out to me when we get there, preferably. But I don't think more words is worse. Frankly, most of this language is from some version of what the state wanted at some point. But I mean, I was kind of thinking it would be when we're talking about the verdict form, but yeah, I definitely don't want to be inconsistent. That would be bad and confusing. Don't want to confuse, want to clarify. Okay, so within 4 years of each other. So back to pattern of racketeering activity. I'm back up at page 3.
Okay.
Defining pattern of racketeering activity. Okay, but see, hang on. So
we're defining pattern of racketeering activity, you need the concept that they have to be within 4 years of each other. And then they're not being found guilty of engaging in a pattern of racketeering activity if what they're supposed to be determining is, did they conspire to engage in a pattern of racketeering activity? But the jury still needs to understand what a pattern of racketeering activity is. So how about pattern of racketeering activity means 1, engaging in at least 2 acts of racketeering activity, 2, within 4 years of each other, 3, in furtherance of 1 or more interrelated incident, schemes, or transactions, and then explain what interrelated is.
I didn't mean to speak over you. I think that is easier.
Okay.
It flows better.
Yeah,
It actually flows better than
it does.
statutory language.
Yeah. Okay. All right, I think that's what we'll do then. So where does anybody have?
Interrelated, and
Yeah.
this is not in the teal edits, but we're doing this quickly, and sometimes as I'm reading it through, I recognize this is not the biggest deal in the world, but I think interrelated might be easier if you said interrelated here means acts that have, and then you pick up that
Okay.
same or similar. Because interrelated modifies acts.
Okay. Yeah, that is definitely clearer.
With regard to criminal objectives,
Hang on.
sorry,
Interrelated here means acts that have
yes.
the same or similar blah, 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 or that are otherwise interrelated. Is that what you're proposing?
It is.
Okay, I think that works. All right, next.
Here, as far as criminal objectives, you pointed out that, as expressed in the indictment, there were some things that were not illegal, wouldn't automatically be illegal in some of the 5 categories that we listed, and you taken 3 of them here.
Yeah.
We do not object to that.
Okay.
I think this encompasses also everything that was illegal in the other 2 categories, and therefore, it's easier for them to remember 3 than it is to remember 5.
Okay.
Does the court plan to give them a copy of the instructions?
Oh, yeah. I always do, even in a one-day burglary case. Yeah. Not that we ever try those, but yes.
Yes. Okay.
There's no reason it has to be a test of memory. I'm not, however, going to tell them that until after I give them the instructions because I want them to pay attention. Okay. All right, so now down to the kind of paragraphy language. My thought was that that would come not within these instructions, but at the very end when we get to the verdict form. But we still need to kind of walk through them and make sure that there's not anything that's incorrect or inconsistent that I'm saying. And Mr. Sharp, you had mentioned, does the first one need to say, knowingly and willfully? And maybe I was thinking, and with the knowledge and intent would be the same, but it probably is safer to just say knowingly and willfully. Okay.
Is that additionally or in lieu of?
Well,
I'm sorry, what's the proposed revision?
for count 1, the state must prove that the defendant knowingly and willfully agreed to join a conspiracy. And then I think it would maybe just say with the intent that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to either get or keep money or other property or participate in the enterprise.
Okay, I don't object to that language, Your Honor. Thank you.
My only concern here, Your Honor, is that I don't know that we need a second statement of intent here. Knowingly agreed to join a conspiracy.
I mean, if I don't say what the conspiracy is down here, I mean, we could join a conspiracy to, you know,
I'm sorry.
do all sorts of things that wouldn't be RICO.
I understand. I think you're expecting me to say something I wasn't about to say.
Okay, sorry.
No, it's all right. Agreed to join a conspiracy, I think understanding,
Oh, instead of with the intent?
yes.
Yeah, understanding is much better.
Or maybe
Thank
with
you.
the understanding that, either way. That way we're not giving them two intent standards in the same.
Understanding works.
Right. With that change, I don't think there's anything incorrect in that, and I don't think it's really inconsistent with what you said before.
Okay.
It's kind of a restatement. My concern is that we're getting the following paragraphs get into, I think, them determining, walking through the indictment and determining, are we unanimous on this one, are you unanimous on this one, et cetera, as opposed to what we were discussing yesterday, which is just telling them, you have to be unanimous that there was an overt act, and you have to be unanimous on which one it was. And you'll be telling them that it has to have come after a certain date. So that covers everything. This is frankly, part of my worry here is that we get a jury who goes in with a very, very long form, they get tired, they go through, they check off a few, and then they say, well, that's good enough, she said we only needed one. And this only works if they go through the entire thing.
I mean, I'm not listing all of them on the verdict form, if that's what you mean.
Then I misunderstood. I was afraid that that's what it
So what I was thinking about doing was saying like, you know, I don't know yet, but defendant X did not join whatever this conspiracy is. If it's did not, that's the end of count one. If it's did, then potentially these are the interrelated types or acts of racketeering activity, or this is the pattern of racketeering activity, and have them listed.
But then now we've turned it into a substantive case, not a conspiracy case. That's my concern.
No, but
This is the pattern that they agreed to. You must then determine which interrelated types or acts of racketeering activity the defendant agreed would be committed.
Well, I don't.
They agreed that they would murder everybody, or whatever they might come up with.
All right. I see. I think I understand what you're is looking at. Problem is types or acts. I mean, are you contemplating that they basically have a menu and they check it off?
No.
And the menu is acts of violence, narcotics, property crimes. I mean that.
I was going to get input from y'all. I don't know.
Well, that might work. I mean, my concern when I read this was I thought we were back to the point where we were looking at a list that just tracked every overt act in the indictment, and I can see a lot of reasons why that could cause problems.
So it could either be, you must unanimously determine which interrelated types or acts, that one's still up for debate, of racketeering activity the defendant agreed would be committed, and then have them listed, or that interrelated types of racketeering activity would the defendant
I think all they have to decide is that they contemplated committing interrelated acts of racketeering activity.
Well, they agreed to, not they contemplated it. You could contemplate it and reject it.
Fair enough. Okay. But that's really the question before the jury is, did the agreement contemplate what would ultimately have become a substantive violation? I'm very concerned about using the word acts because you can see how they can get all hung up on that. And that's not really what the conspiracy law requires the jury to determine is the specific acts. That's what we talked about yesterday. The federal cases I cited to you, they all say they don't have to determine which specific acts were contemplated, only the types.
But even those federal cases say that the jury has to be unanimous on the types of acts that were committed. You'd agree with that, correct?
Whatever the jury's deciding, they have to be unanimous. I agree with that.
And
All right,
unanimous on the types of acts.
Don't talk to each other. Got to
I'm
talk
sorry.
through me. That's just how it works in court. You know that. I know you didn't mean anything by it, but
I
it
always
sometimes
enjoy discussions.
devolves. I don't think it would with this particular crowd we have right now, but
Anyway, Your Honor,
yes.
I believe that the federal cases that Mr. Floyd cites would require the jury to be unanimous
Yeah.
in the types of racketeering activity, and I think it would be necessary for them to indicate which are the types on their verdict form.
I don't think it's required.
Well,
just trying to
shall we
figure
say
out-
helpful? I'm trying to also contemplate if there is, as Mr. Steele might say, God forbid, a guilty verdict in this case, and an appellate court is reviewing, I think without some tiny level of, I even hesitate to call this detail because it's so high level, but some guidance on the basis for the jury's verdict, that it would be difficult to review. And also, we would want to ensure that they are unanimous on the type. So if they indicate the type, that would ensure that.
But here's my issue with type. I mean, so let's say they don't decide, or the jury doesn't think, oh, they decided they would murder every op. Let's say they think they decided, we're just going to hassle Lucci in any way possible. So we're going to steal things from Lucci. We're going to stab Lucci's mama. We're going to do X, Y, and Z. Those are different types of racketeering activity with the same victim. So it doesn't have to be the same type. And that's correct. So that's the wrong word to say.
And it's the one that crept into the case law, but I think
Yeah,
observation is
it's
correct.
wrong.
But-
And I'm sorry, y'all, I'm kind of like thinking through this as we do this, because I've never done a RICO case before as a judge.
And I've never done one that didn't have a new issue pop up that I'd never thought
Right.
of before.
But,
but as Mr. Floyd says, that is the language, as unfortunate as it may be.
well, I'm not going to,
in
I
the
don't care
case
if
law.
language is in a case. If it's wrong as law, I'm not going to use it.
So, Your Honor, to follow up on the point you just made,
It's-
in this case,
Yeah.
what we are really talking about with this enterprise, with this criminal street gang, is an open-ended conspiracy, because they're going to do what they decide to do. And once you're in, you're basically agreeing that you're going to do what that enterprise is going to do. As long as these are things that such an organization might accomplish when you sign up for it. And this is what, when you look at the older U.S. Supreme Court cases, the one that sort of states the bedrock principles, like Pinkerton, for example, basically says, you sign up in a criminal endeavor, you're on the hook for whatever follows from that. The solution to that is not to sign up for it, is not to become joined into it. And in a gang like this, an organization like this, the sort of one of the fundamental tenets is acts of violence and threats of violence against those you perceive as your opposition or competition. You know, that's the path. You know, the real question is, are you agreeing to join in an organization that does those things?
But it's
And that you or somebody in that organization would do them.
Well, right, yes, but that's my point.
Well, I
is
mean, that's the
within
rub.
That's within the contemplation. I mean, when you're joining up, those things have already happened. You already know this is what this organization does. It's not like you joined the Boy Scouts and you found out that they're engaged in acts of terrorism. It's like joining a terrorist organization and finding out they're engaged in acts of terrorism. But I mean, I think this language that we have here is getting at the point, which is, do they contemplate interrelated acts of racketeering activity will occur?
and we do.
And I guess we've already said it up above. If we're not going to say what was it, then we've said the state must prove the defendant knowingly and willfully agreed to join a conspiracy, understanding that one of them would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to do one of these 2 purposes.
And in Georgia law, with the statutory definition, we pick up the same types in there. I mean, it's kind of baked into the definition that you've already got in the instructions.
But, you know, we're in a situation where, and I understand it, where the state does not want the jury to go through and say, we find this act, we find this act, we find this act. And that's the same thing that happened in these federal cases where there was an argument you shouldn't have to find specific acts. And I think that's why the federal courts have gone to, okay, fine, you don't want us to look at these, to have the jury identify specific acts, but they do need to identify, I guess they went one level up to types of acts that occurred.
Well,
But was that a conspiracy case? I mean, as long as I'm saying you have to be, I'm sorry, that you have to be unanimous that they proved all these things.
Go ahead,
I don't
Mr.
mean to
Floyd.
interrupt you. To be clear, the cases that I was talking about yesterday, those aren't verdict form cases. That's where the request was that the jury be asked to fill out a form that went through every single one of them. And they said no, and the jury was instructed on types, not that the jury filled out a form on types. We don't want to it's not I don't want us to back into giving them an essay question. That's not what we ask juries to do. Juries say yes, no. And if we kind of open it up for them to express themselves, I think we're asking for trouble. There's a good reason why we don't do that.
And again, I'm not requesting a essay from the jury. I just think that having them identify what is the type of activity that they have found, or, I mean, it's not my preferred outcome, but some form of check the box, as the state may have indicated, perhaps, just some guidance more than yes or no. And I appreciate that that's what the state would prefer.
Your Honor, I have an idea. We're all thinking out loud here a little bit. What if it is contemplated the commission of 2 or more related acts of racketeering activity in furtherance of one of the criminal objectives of the conspiracy? Because that would actually tie in to something concrete that you're already doing.
Say that again.
Agreed to join a conspiracy, understanding that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity to achieve one or more of the criminal objectives of the conspiracy. And the reason I say that is you're telling them what those objectives are, and those objectives encompass the substantive violation.
And is that a recommendation regarding the second to last paragraph on page 4?
Yes.
Could I ask what that proposed language is again?
Memory test.
To achieve
Well, that's-
one or more of the criminal objectives of the conspiracy. Right?
Yes.
But where are you saying to put that?
Where you have 1 and 2,
Yeah,
instead of sub 1 and 2, in either, you just say acts, racketeering activity to achieve one or more of the objectives of the criminal conspiracy.
okay, so
And the reason I say that here is because those objectives contemplate the violations of A and B.
but how do I know, does it even matter? Do I need to know which one they return?
Done because of Cotton 2.
Well, I don't know what that shorthand for, or what does Cotman 2 say?
Cotton 2 said it is sufficient to prove either or both of the A or
But I don't need to know.
conspiracy to violate either or both of A or B.
Okay, well, I know that, but I don't need to know which one or ones they found.
No, you don't. And that was exactly the question in Cotton. And
I don't think it should be the goal of the court to make the jury's decision as opaque as possible.
Well, I'm obviously not trying to do that.
I didn't want to imply that the court was.
see, that leaves one person.
Well, I'm not allowed to directly address you, Mr. Floyd.
So, can I,
Yeah,
so we were talking about, back up to that paragraph, the second to last one, and Mr. Floyd, if you could just help me follow your train of thought, does that affect what you're proposing in this second to last paragraph, does that affect the last paragraph on that page?
I think it removes the need for the second paragraph.
See, that's what I was concerned about, because the second paragraph still has the unanimously and which interrelated types of acts. So I understand what that Mr. Floyd is trying to incorporate into the second to last paragraph, but it's still leaving certain aspects of the last paragraph out.
Well, I understand.
Is the state suggesting removing the last paragraph?
That's what I just said. I think it obviates the need for it. And remember that as we're discussing this, Your Honor, this all is coming after you have instructed the jury on overt acts. They understand what they have to find.
But they do have to unanimously find which types of interrelated racketeering activity occurred. That must be unanimous.
Well, they have to unanimously find that defendant joined the conspiracy, and then also determine what.
Right.
And Your Honor.
all right. I'm satisfied that they don't have to list out what pattern of racketeering activity they think anybody may have conspired to commit, as long as they unanimously agree that a defendant conspired to commit a pattern of interrelated racketeering activity. Is there any case law that they have to list it out if it's a conspiracy case and not substantive?
First, I'll divide my answer into two parts. Part one, Georgia, no. Part two, I'm not aware of any other jurisdiction that requires it, but certainly not in Georgia.
But, Your Honor, this is my
Yeah.
understanding. It's not just that they have to unanimously determine that, say, Mr. Stillwell joined a conspiracy and with the intent of a pattern of racketeering activity. They have to unanimously agree on,
What it
right,
is.
right. Like if some of them say, oh, he was joined for
Right.
theft, and the other,
Right, okay.
And Your Honor, I think my suggestion contemplates this because by referring back to the criminal objectives, we stated what those are. They only have to find that it contemplated two or more acts in furtherance of one of those objectives, and these objectives refer to specific types of criminal conduct.
Objectives and pattern of racketeering activity are not the same element.
I understand, but each of these says through acts of racketeering activity and then lists crimes. It doesn't just stop at objective. It says you're going to achieve this objective by committing these crimes.
So you're saying that if they find any of those, that any of it was done to further a criminal objective, that even if it was, let's take criminal objective 1, a count of murder and a count, or an act of murder and an act of a threat of violence were what was contemplated, that would necessarily be interrelated because they would have had to determine that it was in furtherance of criminal objective 1, which is preserving, enhancing, protecting, blah, 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 which is a same or similar intent or result.
With the exception of the blah, blah, blah part, you said it better than I did.
Okay.
Yeah. I mean, I think it's already captured there.
Yeah. Thoughts?
we've been moving around a lot. Could I just hear the final proposal, or what we think is the final proposal?
I don't have one yet. His, Mr. Floyd's is that in that first paragraph, that instead of saying to either 1 or 2, that it would just say within 4 years of each other to achieve a criminal objective of the conspiracy.
I understand that part, and I'm not.
I haven't gotten past that part yet, too. I'm trying to figure out, how do I am at the point where, okay, that paragraph says everybody has to agree that they agreed to commit interrelated racketeering, a pattern of racketeering activity. But if they have to unanimously agree what pattern of racketeering activity was contemplated,
then I need to at least tell them that.
Is there any disagreement among the parties that they do have to unanimously agree?
I don't think so. Everybody agrees about that, right?
Unanimously agree with what?
About what pattern of racketeering activity they agreed would be committed.
And state's view of this is that if it is, they had to agree to commit this act, that act, that act. I think we've passed that. I think that.
That's not what they're asking about.
All right. And so when we
Hang on.
Sorry.
Does the state agree that there needs to be a unanimous determination as to what pattern of activity, racketeering activity, was contemplated as being carried out, whether it ever got carried out or not?
I don't believe the statute requires that.
I
And if I can just finish.
yeah, I'm sorry.
The conspiracy has to contemplate the pattern.
Yes.
Yes, right. Does the conspiracy have to contemplate specific crimes?
I'm sorry, that's not what I mean.
I understand. I'm
Okay.
I'm trying to walk through the hierarchy. Does the conspiracy have to contemplate specific categories of crimes? No. All it has to do is contemplate that the crimes will be related to each other.
Right.
Because that's what would form a pattern.
Okay.
But do they have to be unanimous in their determination of whether they tell us what it was or not, of what that pattern was? I'm sorry to I mean, this is probably really painful for everybody,
No.
but
And I don't
we
mean
need
to
to get it
interrupt.
right.
I don't mean to interrupt anyone. I'm just looking at a case from the 10th Circuit, U.S. v. Randall. I'll give you the site in just a moment, but I'm sure the state knows it. And I'm reading where they're trying to decide what circuits to align with. Yeah. And they state further, we now join the circuits discussed above in concluding that for a charge of RICO conspiracy, and this is as the state says, a jury need only be unanimous. Well, they don't say this. A jury need only be unanimous as to the types of predicate racketeering acts that the defendant agreed to commit, not to the specific predicate acts themselves. And that's where I thought that we were in agreement with the state, that there needs to be unanimity. And I know you don't like the word types, and that's their language, not mine, Your Honor. But there needs to be unanimity, and let's call it the pattern of the predicate racketeering activity. And that's the 10th Circuit, and I believe they're agreeing with a number of other circuits.
Okay, so how about if we just say, would this work? Is this correct and sufficient? You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed.
That's acceptable to Mr. Kendrick.
Sure. You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be permitted.
Committed.
What did I say?
Permitted.
Committed, sorry.
Your Honor, I do have a problem with that.
Okay.
Because I think the jury is going to read that as they had to agree to commit specific acts. I know that's not what you're intending to instruct them, but I'm afraid that's what they're going to hear, and that's what the argument we're going to get.
Then we can say,
contrary to the law.
you do not have to be unanimous about specific acts, ... only
You know, I mean, let's just nip
Unanimous.
it in the bud. Just tell them.
That would be great,
Only unanimous in the pattern.
that there would be a pattern.
Oh, we're so close.
And what the pattern is, really.
Right,
A specific matter.
yeah.
Well, the word specific just is another way to.
We
back
won't,
into
we
the
won't
same
say
problem.
specific, unanimous. I mean, I just said it, so I'm not going to say it again. You do not have to be unanimous about specific acts, as to specific acts, what?
You do not need to be unanimous as to any individual acts?
Individual I worry about, because most people
As
think
to.
of individual, they think of a person.
Single act.
I like specific.
You do not need to be unanimous as to specific acts.
I think that's accurate.
Can you read it back as a whole,
Sure.
Your Honor?
You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts.
Are you going to say that after, if you unanimously determine that the defendant joined such a conspiracy, and then say what you said? I'm just going by the last paragraph of page 4.
I mean, yes, I don't even know where that language went, but what did I say? After the first paragraph, then what did I say? If you,
You mean, what did you previously have in this
Yes.
document? The document originally read, the one sent to us at lunch, after that paragraph. If you unanimously determine that defendant joined a such conspiracy, comma, you must then determine which interrelated types, with the S in parenthesis, or acts of racketeering activity the defendant agreed would be
okay,
committed.
no, I don't think I'm going to say that anymore. I think because I am saying the state has to prove they, agreed to join a conspiracy, understanding that somebody was going to commit at least 2 interrelated acts of racketeering activity, and within 4 years of each other, to either get or keep money or participate in the enterprise, or to achieve a criminal objective of the conspiracy. I think maybe then, right there, just put in parentheticals, quote, pattern of racketeering activity.
Sorry. Did we lose your...
But then there was the language.
I know, I hadn't gotten to it yet. I'm sorry. Sorry. I think I would then just say you must be unanimous in your determination as to the pattern of activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts. I don't know.
That's acceptable to Mr. Kendrick.
Okay.
Could we get a brief break at this point?
Yes.
Your Honor, obviously, I'd like to look at the final words, but I think, in principle, I think you've got it.
All right. Yeah, let's take a quick break.
Thank you.
All right, are we, enough of us back that we can dive back in? I think I may have come up with a way to say this. So we had talked about in that kind of first paragraph, whether to say that either, money or property or participate, or instead to say to further a criminal objective. Was everybody in agreement about that, or no?
Are we on page 4, Your Honor?
Yes.
Is there any way possible to throw that up on the monitor?
Yes, I could screen share. I could join Zoom and screen share.
That would be very beneficial.
What a great idea. Okay.
Thank you.
Bless you. I think I'm in Zoom already.
Thank you, ma'am.
I'm not usually the one sharing, so. A moment, I've got it. I just have got a lot of things open, so I think it's this one. Is that the right one? Okay.
Oh, that's very helpful. Thank you.
We should have maybe been doing that the whole time. All right, so one thing I've thought about is just kind of lead in, hey, y'all, your verdict as to every count needs to be unanimous. That means you need to be unanimous in your determination that the state has proven every element of that count beyond a reasonable doubt. For count 1, here's what the state has to prove. And I've put all of it in there. And I don't know whether we want to say to achieve a criminal objective or the one or the other. We can decide. But I'm going to say all of it. They have to prove all of this, and then they also have to prove, an overt act. To be unanimous on this count, you must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. You do not have to be unanimous as to specific acts. You must also be unanimous as to any overt act or acts committed to further a criminal objective of the conspiracy. And then whether we want, again, the reminder that it has to be after May 10th, whatever. And then as long as they're unanimous on an overt act, do they have to list the overt act? Or do I just, it's kind of the same question again.
State's positions do not. They do need to be unanimous. There was one, and which one it was, but they don't have to list it. They only have to be unanimous as to one.
Your Honor,
Yes.
for the record, I am objecting to that you do not have to be unanimous as to specific acts.
Okay.
However, having said that, if Your Honor is going to include that, to me, the last sentence that Mr. Floyd is objecting to doesn't make a lot of sense, because we're telling them they don't have to be unanimous, and then we're telling them you should note on the verdict form.
That's what I'm asking. Do they still have to?
Right. If we're going to keep in that that you do not have to be unanimous as specific acts,
It's confusing
as a juror, it wouldn't make much
to
sense.
then say you have to unanimous about an overt act.
Those are different acts.
I know, but are they going to know the difference? Acts of racketeering activity? Maybe that's the way to clear that up.
Okay.
Would that work better?
I think it would.
Okay.
And then I understand the state does not want the overt act on the verdict form. The defense would want or at least Mr. Kendrick would want that on the verdict form.
I would.
Which one it is?
The one that says you should note on your verdict form any overt acts in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. I would like to see that on the verdict form just to ensure that they did pick one within the proper timeframe.
Okay.
I'm not sure how council contemplate that this would actually happen. Would they list a number, or would they?
They'd write out, I don't know. I mean, I guess if it was an act in the listed out, they could just list the overt act number.
And I think, all right, this is why I'm asking, Your Honor, because they could also find an overt act that isn't listed out.
Well, then we'll
they
give
would-
them a little blank for
Yeah.
that.
I mean, I'm serious, like, literally
So am
to
I.
say, and, you know, do you find, you can list them by number, or you can list an act, anything else that you determine is an overt act, and they can go ahead and do that. I'm trying to think of physically how this happens without them, and I'm not, to be clear, I'm not saying the state doesn't object to that. I'm just trying to figure out what it is we're talking about before I address it.
How about that?
And Your Honor, if you could scroll up toward that long paragraph in the
what
middle
that
of page
means?
4, there where it says for count 1. I think that's as concise as you can possibly make it, but I'm wondering, given that it's such a complicated paragraph, if it might benefit just from a formatting perspective if you broke it up the same way you did on page 1, where the different
Okay.
elements are on different lines.
For one thing, we need to decide, is it going to be, are we going to say this? Or are we going to say, well, that did not help at all. Which of those two things are we going to say? There.
Oh, yeah, I'm just studying for a moment.
So the orange is what Mr. Floyd had proposed. The blue is what I had originally. And we could have the i.e. a pattern of racketeering activity. That actually doesn't go there, that goes up there. Oh, no, it doesn't, because it has to be to achieve a criminal objective of the conspiracy.
I agree with that. I think the get or keep money or other property and participating enterprise is wrapped up in the statement of the criminal objectives which you've given them before.
Yeah, I know you think that.
Yeah.
So thank you. What does the defense think? And actually, Mr. Floyd, do you think that this survives appellate review as giving them the correct instruction?
Your Honor, I may be right, I may be wrong, but that question is forefront in my mind in everything I'm saying.
Okay.
Yeah. and part of that is the appellate analysis, which is and this is why I've been referencing where you've said things in other places, you know better than I do, the jury instructions are read as a whole. And
I
think
know.
that encompass, given what these instructions have elsewhere, that gives me a good deal of comfort.
Your Honor, my preference is more for the original language with the caveat that might actually go against me is that I'm just not entirely clear what participate in the enterprise means.
Yeah, me either, but that's the way the statute's written.
Um,
I mean, honestly, I think it's, Mr. Floyd's might be more elegant, but the original tracks the statute, and we're less likely to commit error by tracking the language of the statute. Because if you go way up above to what the elements are, one of the elements for Part B is participate in the enterprise through a pattern of racketeering activity.
Right. Yeah. Obviously, I can't challenge that, Your Honor. I was looking at in the language that I was suggesting, I was looking at number 7, where you list the elements, which references the criminal objective. So, circling back to that, I'm trying to be consistent in the language.
I mean, the other way we could say it would to join a conspiracy, understanding that, no, it's just too awkward. I'm trying to flip like the order of them, that they would get or keep money or participate in the enterprise through, but I'm not going to do it that way. All right, it's just going to stay like that.
and then drop a comma after the 2017.
Oh, yeah, you know, we're just going to have to agree to disagree on that, because I'm sorry, but I don't like to offset the year with 2 commas. Sorry.
Do you use an Oxford comma?
Oh, absolutely.
Okay, well, we can agree on that.
Okay, yeah. All right, and so then they're being told they have to be unanimous about the pattern of racketeering activity, but not specific acts of racketeering activity. They need to be unanimous that at least one overt act was committed in that time frame, and then they're going to list on the verdict form whatever acts they unanimously find. And then probably when we get to the verdict form, which we need to do soon, it's going to be, you can list them out by act number or write out what you find.
I understand, Your Honor. For the record, we do object to that last sentence. I don't think it's necessary. I understand that you disagree with me. And I'm just
I don't know if it's necessary, but it's not error to do it. Is it? Okay.
That language itself, I'm not certain that it's error, Your Honor. The question is really, this is one of those devil in the details things, which is going to be exactly what that verdict form says when you embody that language.
Well, I've invited people to submit proposed verdict forms. So now that we know what the charge is going to be, I would continue to welcome that.
I understand, and we will modify our proposed verdict form because now we have a better idea of what the charge is going to be. Thank you.
And I'm sorry, it's just not an easy thing to do. Okay, so I shall stop screen sharing. for now. All right, we need to circle back to a couple of items that were on the rest of the jury charges. And I don't mind if it would be helpful to share this one as well. Was that helpful?
Very helpful. Thank you.
Is it the version that was sent last night? It should be, yes.
Yes, I haven't done anything to it. So I'm just going to scroll through unless anybody has thought of anything else to where we had noted we needed to. All right, the stipulations.
We're working on that as we speak.
Go back up to the beginning and take out the counts on which a directed verdict was granted, which were counts 59, I don't know how to do that one. Laura, can you take that for action? Because I don't know how to get rid of the. Thank you. 59, 60, and 62 are out.
Yes, you're right.
And then
I don't know if that's changing on both figures. Is it?
63 is not gone completely, it's just different now.
Now it's a 131 instead of a 133,
Right.
correct?
Maybe we take off the language, he was convicted of a felony, we just say possession of a firearm by a convicted felon.
Right. Right, just ditch the previously convicted of a felony part. It would just be possession of a firearm by a convicted felon, 131. And we'll just have to explain to them something, I don't know what. All right, so then from Mr. Stillwell, 52 and 64 change. All right. Y'all are still working on the stipulations. And the stipulations, once you write them up, they can just go out with the jury? Or is that what they're going to do? I mean, in which case, if they're going out, I can just kind of generally say about these topics instead of reading them, or I can read them, whichever. So, I mean, normally it's like a piece of paper that's, you know, joint exhibit, whatever it is. I don't know if y'all have done any more joint exhibits, but
So maybe we just make reference to the joint exhibit numbers?
yeah. Okay. Have entered into, the parties have entered into stipulation about certain facts. And then,
I think there's 4 separate stipulations. So I don't know if it would make given each number.
these,
Is that correct, 4?
bad typing, but we can fix that later. These 4 stipulations will be are marked as joint exhibits. We can make it pretty later. Okay. Oh. Really bad typing. Maybe I shouldn't type while it's on the screen. And then where the parties stipulate that's in the nature of evidence. All right. Apparently down on 13140, there was a question as to whether you were going to check, Ms. Hilton, on whether any of the criminal convictions were for a crime of dishonesty or making a false statement.
I don't think they are.
Okay, well, at this point, we're just going to say felony.
Yeah, they're not sure.
Okay. I don't know why this is highlighted.
Because I objected to it,
Okay.
but it's pattern, so I understand.
I've got a question. I mean, yes, a conspirator is an accomplice, but do we need to use both of those words here when we're saying where the witness is an accomplice? It wouldn't hurt to say or co-conspirator. Thoughts, anyone?
I have preference.
You don't care? I mean, I guess we're going to tell them, here's how you can, okay, I'll just leave it the way it is if nobody has any preference.
Actually, I'm sorry, Your Honor. I think it's a good idea to put or co-conspirator in there. Just to prevent confusion as to about accomplice.
Anybody care whether we say on its own or by itself?
No.
We'll just go back, and I'm not going to do this right now, but we'll just say or co-conspirator for all of those. So I'll just highlight that, and we'll go back and do that. All right.
Your Honor?
Mm-hmm.
I could be mistaken, but the only concern with the accomplice or co-conspirator is that corroboration of an accomplice instruction. If it's truly a co-conspirator, it's not
You're
that same
right.
legal principle.
You're right.
I just don't. Thank you, Your Honor.
All right. And we're instructing them separately about. Sorry. All right, and the defendants have both chosen not to testify, so we now know that. Any ideas?
do.
Coming back to here, y'all.
That's what I'm trying to figure out.
I think on the one above, we were trying to determine if that was appropriate, because did we really have a photo lineup type scenario where that would apply? I don't. And I think we were adding accomplices to the one below because we were trying to think through, there were no photo lineups type scenarios involving Mr. Kendrick.
Yeah, there's no eyewitness identification really of either of these defendants.
However, there was to certain overt acts that were not these gentlemen, specifically Mr. Demise McMullen, Mr. Walter Murphy in a shooting case.
Right.
I remember that, and there's probably
Okay.
others. So we were trying to figure out how, if you look at 135.
Well, and it's not even just lineups. I mean, it's like the girl who was in the car that identified Ryan as the one who killed.
Right. And so I think that probably needs to stay in there. So I think in 135.11, what we were struggling with is it's written.
Yeah.
Defendants.
Yeah. Right. So.
Can we, I don't love the conspirator because it's almost, I know it's not intended this way, but it's almost like a suggestion that Ryan is a conspirator with us or Walter Murphy is a conspirator. Can we just say individual? Identify an individual? Rather than put a label on it?
Your Honor,
Yeah.
the only, I'm thinking through in terms of, if it's not in regards to a defendant, the beyond a reasonable doubt, like the germane issue of this is, how a jury's gonna weigh
Right.
a pretty
Yep.
significant identification of the
Yeah.
defendant in a crime.
Well, except that when we're dealing with the overt acts, even with Mr. Ryan, I mean, the overt acts still have to be proven beyond a reasonable doubt. So I don't think the standard is any different.
Now, this, I have no idea as the perpetrator of, I mean, it's not necessarily crimes that anybody's charged with if they're overt acts. As having committed,
The perpetrator of the act?
Yes.
and then not the party, right?
Correct.
Party. The perpetrator of or party to the act.
Or act/crime, whatever.
Well, act is broader. That'll be crime.
Okay.
The act/crime?
Just
The act. Do y'all want this part at all?
Yes, please. If we have not.
That a defendant show
That the individual?
that another person committed any alleged offense. This part's weird because of our overt acts.
If another person committed the alleged act? Perpetrated the alleged act?
That okay with the state? Just change offense to act?
Yes, Your Honor.
Okay. And then I guess we're fine with that.
I mean, if we're going to say this part, I mean, I don't know that we need to say this part at all right now.
Or maybe prove the problem is, these are written for the quote-unquote defendant.
Yeah.
But theoretically, we are, myself and Mr. Weinstein and our clients are essentially defending not only our clients, but other individuals as
Right.
well. But the burden of proof doesn't rest with us, so
Right.
it rests with the state. So I think that's an appropriate, I would just, maybe instead of, I would just go back to the more inclusive individual or.
But they don't have to prove a specific individual. I mean, they could prove some unindicted co-conspirator committed one of the overt acts. And so by definition, we might not know who they are. I mean, it says up here beyond a reasonable doubt. I think that's really all we need to, it's not necessary that the defendant show that another person committed the alleged act. I think the rest of this, because it's written for something that's totally not applicable here, maybe just is confusing and also not necessary. What do you think?
The state agrees that the remaining 2 paragraphs are not needed, Your Honor, for the purposes just outlined by the court.
But it seems that the last paragraph would apply when we're speaking about indicted or unindicted co-conspirators, but we have to change the language. Actually, I don't know what to do with that.
I do.
Could we add on the end of that paragraph that remains, like the burden of proving.
The burden never
identification,
shifts to the defense.
Or the burden of proving identification, the state bears the burden of proof, yes.
What?
And that's what you do with the last paragraph.
The state has the burden or bears the burden of proving identification beyond a reasonable doubt. Well, we already have it beyond a reasonable doubt, but bears the burden of proving identification.
Say that. And then in the beyond
No.
reasonable doubt.
How about just the burden of proof never shifts to the defense?
That sounds fine.
The state agrees, Your Honor.
All right. All right, I'm going to give that, so we're going to unhighlight that.
Yep, I got it.
Knowledge. So some of these come out. Yeah. I'm going to say a firearm here. Okay. Yeah, but they only have to.
Your Honor, before we get too far, the only thought with the knowledge piece, of course, the court outlines the crimes provided. The state just wanted to make sure and was thinking, out of an abundance of caution for the jury to understand that, RICO is not what, this paragraph is envisioning in terms of that knowledge requirement. I mean, the court or the state was thinking through out loud if, this specific provision or instruction, of knowledge doesn't fit the RICO instructions are kind of in their own universe.
Well, that's why it doesn't, I'm sorry. But you give a set list.
Be proved by the state beyond a reasonable doubt. In order for you to convict on those counts. Does that work?
Yes, Your Honor, or this instruction is limited to these, counts or.
I think that it sufficiently says this doesn't include RICO.
Thank you, Your Honor.
Okay, appreciate you bringing that up. Okay. All right, I'm saying this before the RICO also, but I don't think it hurts to say this one. Is this multiple ways of committing a crime only applicable to RICO?
No, Your Honor, I think when
All right, Laura, do you want to just delete all of the RICO stuff and drop what we just did into there?
Your Honor, in answer to your question about more than one way, that there are gang act charges here which allege more than one type of criminal street gang activity as the, I hate to use the term, but predicate or foundation for the criminal street gang violation. So we have that issue there too.
All right, so I'll just kind of say that in here in the midst of it, and then I'll say it again before I'm talking about RICO. Okay, criminal gang activity. Counts 50 and 57. This one may have to be separated out for each defendant if we're listing crimes.
Well, we could put.
Or we could
without
put-
looking at the statute, I don't know the term of art, but I think it's criminal gang activity. And
Yeah.
then I think we could just put the following offenses
Where did
would
it go?
constitute, if proven, would constitute criminal gang activity.
I have no idea where that.
But count 57 is pretty specific as to what are the actions.
I can't. What was somebody saying?
Well, you had the blank, and it looked like you were looking. I was interpreting that as you were going to add a specific offense, and I was thinking you would just put criminal gang activity as defined.
I mean,
And then we define criminal gang, it's defined, I think, above, but
it's not. Oh, yeah,
Your Honor, in that
Yeah.
paragraph where it has criminal gang activity, I believe there needs to be possession of either marijuana with intent to distribute, because it has any criminal offense that involves violence, possession of a weapon, or use of a weapon. So
Yeah.
there needs to be a comma, possession of marijuana with intent to distribute, because that's not defined in the first criminal gang activity. But it is
we don't have use of a weapon alleged, right? Oh, yes, we do. Never mind.
You have it defined below, but not in the first criminal gang activity paragraph,
So possession of marijuana,
with intent to distribute.
does it have to be with? Okay.
That's the only charge left.
Does that capture all of it?
Yes, Your Honor.
So I think. Why is that
But
not?
don't, I'm trying to understand, Your Honors, down here below where you have 50 and 57 lumped together.
Because that's subsection A. Subsection B, as a leader, or no, I'm sorry, to maintain or increase his status or position, which your client is not charged with.
No, but here's what I'm trying to understand,
Yeah.
and I need the court's help. In the indictment for count 57, if you look at that
Yes.
count, and again, I'm not really arguing, I'm just kind of hoping for some enlightenment.
Okay.
The street gang activity under A is, the offenses are specifically listed: possession of marijuana with intent to distribute, and then the codeine and the cocaine, which have been thrown out,
Right.
and then possession of firearm during commission of felony. So shouldn't, for a conviction under 57, one of those two things need to be found?
Yes, which is what the blanks would be.
Yeah, but that would apply to 57. Isn't it different for Mr. Stillwell in 51?
Yes. Yes.
Oh, I'm sorry. Okay. I
It's
understand
okay.
now.
I mean, so it may be that,
Or 50, I guess.
it may be that right here, we just say criminal street gang, or whatever it is, criminal gang activity. And then below, what typically happens then would be, can somebody look up never mind, I've got it right in front of me. No, it's 5.3 that lists what the gang activity is, right? Yes, Mr. Sharp.
So I would suggest we just put in criminal gang activity, and then we have the definition of criminal street gang, and below that, because we're just kind of going, I'm thinking sequentially by the elements. Below that, we define what you're about to talk about right now, criminal gang activity, and then we bring that paragraph that was just above all these elements, drop it down to there.
So you're saying move the criminal gang activity paragraph down?
Down, because it's like we're giving the definition before we give the elements. So we give the elements,
Okay.
and then we follow with the definitions that are needed.
Where in 1615.3 is anything about drugs? Is it just because it would also be an offense of racketeering activity?
Yes, Your Honor.
Okay. All right. Okay, so these would both say criminal gang activity, right? and then take this and move it down below. Is that what you're saying? That makes so much more sense. Thank you. Commits a crime that constitutes criminal gang activity. Well, I guess we'll do criminal street gang and then we'll do criminal gang activity. Right.
I have a feeling you only had that criminal gang activity below, because we'll get there.
What?
I have a feeling, as we scroll down, we have criminal gang activity. Right, so we kind of said the same thing twice.
What are we doing?
Right where your cursor is, well,
Yes.
above malice murder, there's two paragraphs that right now are redundant.
This second paragraph begins to delete around as charged in this case.
This?
That and the paragraph above it both say the same thing in different ways.
Criminal gang activity means we don't have conspiracy to commit, right? Yes, we do, sorry. Well, that's the definition, right? So what are y'all saying?
You're saying as charged in this case, and we kind of.
So, I mean, I think it needs, I don't think we need that, but murder, possession of marijuana, we don't have these anymore.
Okay. Your Honor,
Yes.
may I sit so I can see my screen? In count 57,
Yes.
and again, maybe I'm just not understanding this, maybe I'm just tired. In count 57, the criminal street gang activity is alleged to be based on the commission of one of
Possession of marijuana with intent to distribute and possession of a firearm.
right, so, but not murder.
Right, but
You have murder, but the problem is the way that it's worded with 50,
which is why we may need to separate this
with
one
57.
out.
That's what I'm trying to say is murder is not included in 57 gang activity.
I understand.
Okay, thank
But it's
you.
not going to be, they will have the language of each count when they do guilty or not guilty. And so when they get to count 57, the gang activity alleged against your client is not going to list murder. It's just going to list possession of marijuana with intent to distribute and possession of a firearm as alleged in certain counts.
Okay,
Okay?
as long as it's clear in that form,
Okay.
then I'll be okay with that, Your Honor.
58, 59, 60. Okay. So we're now we don't have to define this non-pattern charge because they're not being charged with it. Nor do we have to do possession of a machine gun. We do have to do possession of a firearm. 131, though. That is a pattern, right?
Well, Your Honor, machine gun is an overt act, so if we're.
Okay, well, why don't you just give me that again when you send all of the overt act things? Because I may actually. Okay, well, it's already in this or somewhere else? Right, but is it dropped into here anywhere yet? Okay, all right. Okay, we just need to pull the pattern for 131 then and put it in whatever that document is that Mr. Atkins sent. Okay, so
does this say? Oh. It's just any felony, right? If it's 131? Okay. We might need to look at that whole thing again to make sure it's correct, but. All right. So possession of a machine gun. Laura, can you just lift that and put it in with the rest of those overt act explanations? Thank you. Possession of marijuana. We don't have that, right?
Correct. Well, that'll be.
We have it, possession with intent to distribute, right?
The marijuana, we do have it after the overt act.
Okay, well, that will need to go in where the overt acts are explained. So did y'all send that separately? Laura, will you just make sure that one gets grabbed also? We only have marijuana, right? No controlled substances now? I guess we'll still need this for some of the charges that exist, because, right? Yes.
Yes, sure. Although, Your Honor,
Yeah.
could you scroll up?
Mm-hmm.
Please?
More?
Well, if it's the over, I don't, on behalf of Mr. Kendrick,
Yeah.
the state must prove the defendant possessed.
Oh, right, right.
The codeine and cocaine. Thank you.
Good eye.
And there it is again in the next paragraph.
Oh, see, now you're taking credit.
Oh, no, I'm going to do a word search later.
It's also.
Yep.
That's what happens with cocaine.
It's everywhere.
It's everywhere.
Okay.
Right there, sir. In the sentence above, Your Honor, if you go back up to equal access, the second line.
Thanks. Okay. We still haven't gotten the verdict form, but
Your Honor,
mm-hmm.
the state did send a verdict.
Oh, I'm sorry. Yes, I know. I mean, we haven't settled on one yet, nor have we reached a point of discussing beyond what we've. Yeah.
I want to make sure.
No, yeah.
And I would really like some time to, I understand that you gave us a heads up on the verdict form, but I'm still going to need time to weigh in on that.
All right, so I think that's everything for this one, other than making sure of that. But now we need to go through, is everything patterned for the other crimes that are only other acts? No? Okay. Why don't we get out of this? And do you want this forwarded again to you so everybody can take a look at things that we might have missed?
Sure. Could we save it under a different title?
I mean, I guess we could do that. Yeah,
I didn't mean that sarcastically, Your Honor.
Your Honor,
I know.
Your Honor, this is probably, of course, but the RICO that we worked on as well, instruction?
It's embedded.
Okay.
Yeah, it is in there now, thanks. Okay, let's see. All right, Laura, I'm just going to let you, are you going to be the one to share the? I can, but I. Which would be easier. Okay, let's everybody take a minute. What's the date? November what? Thank you. So I'm going to title this November 20th, jury charges with RICO, and then Laura, you can send it. Whenever. They don't need that right now.
Well, we'll add, because we'll have to add all this in as well.
Okay. All right. And,
So I'm sharing this now.
okay.
So this is what the state sent over earlier. Obviously, I took the title off, but.
All right, so what's on the screen now is everything that would cover anything that's a crime in the overt acts.
Except there may be a couple we need to add back in based
Okay.
on other things, but.
What is this called in the, this is in, this in the jury charges thing, what is it called? Okay. What a good title.
So, okay.
You know what I'm saying?
Mr. Weinstein just brought up a point to me.
Okay.
With these overt acts, the pattern charges refer to people as defendants, and I don't.
Yes, no, we definitely don't want to say that. So maybe we can just do a global replace of someone,
How
a
about-
conspirator,
How about actor?
Person. I definitely,
Person?
a conspirator.
The
I think
person.
would be
I don't want-
comment on-
I mean, okay, but maybe the person assaulted another person,
or
Actor.
the other person, the
Actor.
person, that's just going to get confusing.
Actor.
Perpetrator? Perpetrator. Okay, so do you know how to do a global replace? Okay.
or maybe
Alleged
alleged
perpetrator.
perpetrator, yes.
Okay. All right, so we'll change defendant everywhere in there to alleged perpetrator. And then,
Can I ask why conspirator is not appropriate? Because you have to be either an indicted or unindicted conspirator to make everyone guilty. You can't just be some,
a conspirator, maybe?
yeah.
And alleged, because,
Alleged conspirator?
well, no, because they'd have to actually be a conspirator.
Right, but I'm concerned if Your Honor gives jury instructions saying the conspirator, that is not intentionally, but.
No,
it's
but
a
might be
comment-
saying, hey, they are conspirators, and
Right.
we don't want to do that. That's for them to decide.
I know that's fair.
Okay, so the perpetrator.
Alleged perpetrator.
The alleged perpetrator, sorry. All right. All right, so there are two non-pattern charges. Criminal use of an article with an altered identification mark. Can y'all see that on the? I'm not the screen sharer right now, and Ms. Persfield's doing like 7 things at once.
There you go. That's where
Thank
we're at.
you.
I'll finish the rest of it.
Okay. So what are they alleged to have done, whoever had this? I mean, we want to get rid of the language that's not applicable, so.
It's just concealed.
conceals, when he conceals,
And it's Act 53, Your Honor, in the indictment,
thanks.
which Trontavia Stevens, and then it goes on, criminal use of an article with an altered ID by possessing a firearm from which the accused knew the identification mark had been removed for the purpose of concealing and destroying the identity of said article.
Oh, okay, so it's, a person commits the offense of whatever that is when he possesses, right? A firearm?
Yes, Your Honor.
I'm sorry, say that one more time.
Okay, so when he, and then get rid of from or all the way through possession, and then change it to possesses a firearm. Yep, which he knows. All right, and then that's it. Then I think it's fine.
You can take out nameplate, it's serial number, right?
We can, yeah. The manufacturers, what was alleged?
Serial number.
Okay. Serial number.
And we can try to.
Or are there distinguishing?
And it said,
What it alleges is the identification mark,
correct, Your Honor.
which, did y'all mean that to be the serial number?
I believe, Your Honor.
I think it's fine the way it is. Okay, and then implied, what is this? Why do we have that? Where did that come from? Number 10.
I include that in all my murder cases. McBurney gives it all the time.
Is that not in our,
Abandoned and malignant heart isn't defined. It's from, obviously it's a non-pattern charge, so I get.
I think we have malice in there, and we say malice can be, it's essentially, I'm paraphrasing, malice can be formed within an instant or something to that effect in a pattern. I think this is unnecessary because we already discussed malice in a pattern.
The pattern just doesn't define what an abandoned and malignant heart is. This says an abandoned malignant heart may be inferred from the circumstances.
Why do we need to
hang on,
define abandoned and malignant heart?
hang on, y'all. Let me get to the patterns. So it's,
For the reason that Mr. Bach just said.
for malice murder. Because the pattern says you may also find it when all the circumstances of the killing show an abandoned and malignant heart, which nobody knows what means, even though there have been case after case after case about what it means.
And maybe we don't need the first
So,
sentence. We just need the abandoned and malignant heart sentence.
So, yeah, part of it's covered. We say you may also find malice where there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. So that first sentence is already covered. Oh, and the second, well, sort of the second sentence. So basically you're looking for a definition of abandoned and malignant heart.
Yeah, the first sentence I just put in there.
Okay.
Where it could be put in the pattern charge.
Is there any definition in the, like, bench notes of the pattern that define it? All right, I'm not going to do that. Delete that one. Is that everything? Those are all of the charges that are in the,
I just added possession of machine gun.
okay, well, all right.
It's out of the other set, but we'll go figure out how we're gonna do that.
Possession, oh,
And then I guess you're going to need to add the codeine and the
possessed a machine gun.
cocaine back in if it's not there.
Wait, that's, they don't have to have possessed a machine gun during other crimes. They just have to have possessed a machine gun, and then we need to define what a machine gun is. I think we lifted the wrong one.
That's what we have in there.
Okay, well, we need to work on this one. That a perpetrator possessed a machine gun. A machine gun is any, yes, period. Yeah. I think that covers it. Right?
And then, I don't know what happened to the codeine one, but we'll get that. The codeine
131, I don't know.
and cocaine. Is there anything else? We might need
Theft,
theft by receiving stolen property, if we have a few theft by receiving stolen gun charges.
those are overt acts that aren't, okay. Well, can you quickly grab the pattern for that? Is it theft by receiving stolen property?
Yes, ma'am.
All right. Is that a separate?
Can we go back? Can we go back to the machine gun when you get a moment, Your Honor?
Okay, yes. Theft by receiving stolen property is 2.64.80, which Laura, I can grab and drop in here, but will it show up on?
It should.
Okay. I'll just put it right there. Does that show up? Oh, well, you'd have to move it to that part. I put it right above possession of a machine gun. Is it there? Yeah. Okay.
Okay.
And obviously we'll need to change defendant again, but
Can we go back to what you removed in machine gun when you have a moment, Your Honor?
I'm not the one moving it.
Oh, okay.
So yes, but we have to be patient with Ms. Percival.
I believe you removed language about commission of a crime. That's in the statute, and it's also the way.
On machine gun?
Yeah, it is. It's A1. It shall be
What's
on.
the statute?
It is 1611-160.
Thank you. Have also never done a possession of a machine gun trial.
Well, there you go.
1611-150. Okay. 160.
On the machine gun? I will as soon as we get there. I have to get this added back in.
Oh, how interesting.
Yeah.
How odd.
I don't know why that is, but I'm not going to question the wisdom of our legislature today.
Okay, so it shall be unlawful for any person to possess a machine gun during, okay, so I guess we'll go back and lift them back.
And then in the count, there's a specific list of the offenses.
So it's only alleged that so that would be the two that are left, the possession, during the commission of possession of marijuana with intent. Are
Actually,
other people charged with
Yeah.
possession of a machine gun?
yeah,
All right.
there are. And so there's a list in 62, which probably should be included here, which is criminal street gang activity,
62.
possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine.
Possession of a machine gun.
I can read those off, Ms. Percival, if you'd
Well,
like. Okay.
as it's indicted, it's participation, it's everything that's in 62. Is that what you just said? Okay.
Yes, everything in 62,
All
Your
right,
Honor.
so we can lift that from
Okay.
the indictment.
Thank
Or
you.
Laura can just type it right now. Okay, what else?
We'll need to add back in, Your Honor, possession of methamphetamine with intent to distribute, hydrocodone with intent to distribute,
Hang on just a second. Why are we adding those back in?
because those are Act 69 and Act 70, they're overt.
Overt
acts.
acts. So are there overt acts that are possession of a machine gun?
Yes, that is,
And those are 69 and 70?
no, I'm sorry. Possession of machine gun is 188.
So they were alleged to, Kitchens and Williams were alleged to have possessed meth and hydrocodone with intent to distribute at the time that that raid occurred?
No, sorry, two separate conversations, so I should finish.
Okay. So the machine gun one is fine now.
Yes,
And you're saying separately, as offenses that we explain, got you, we need to do possession of meth and possession of hydrocodone with intent to distribute.
and possession of MDMA, which is Act 77.
Okay.
Hang on, real quick. Which ones are intent to distribute and which ones are possession?
All of those are intended to distribute.
Methamphetamine, hydrocodone, and MDMA.
Those are all intent to distribute?
Yes.
Okay. And is there, other than the cocaine, is there anything that's just possession?
Do we,
No,
do we still have a possession, a simple possession of marijuana as an overt act?
I believe we do.
I don't know, and I know we're all speaking at once, but I don't know if you would need to do MDMA because it's Act 77 and it's just referencing what Mr. Nichols had been previously convicted of to make him guilty of possession of a firearm by a convicted felon. So we don't need that.
Ah, so we don't need that. Thank you.
Thank you.
So it's MDMA, no.
And the hydrocodone, no.
No, we need hydrocodone.
We do?
Yes.
We do, that's
Oh, sorry. Okay.
Act 70 for
Sorry.
And if we don't, I think we added it back, but possession of codeine with intent to distribute.
Yeah.
Yes. I'll try to go back for a double check.
Your Honor, I'm double checking. I'm just control Fing possession in the indictment to make sure I'm not missing
Okay.
anything. And there is Act 49 has possession, simple possession of oxycodone.
Okay, so on the possession, do you want them listed separately? I guess so, yeah.
All right, I think we're getting to the end, but I need a quick break because I didn't take one when y'all all did earlier. So I'll be back in a sec. Y'all can take a break too.
Thank you.
Thank you.
All right, while we were on the break, I think Ms. Pursfield caught a couple more charges that need to get included that were, I think, maybe drug charges as well. So we'll get those included. And then we will send out to everyone to take yet another look at these jury charges, including all the RICO we just did, the overt act crimes that we are just now including, and then hopefully everything edited correctly as to the rest of the charges. I think when we define the crimes that are just overt acts, they're not counts, that we need to set that off somehow, and I'll just kind of say, hey, you're going to get a list of alleged overt acts, and some of them are crimes. So I'm giving you the definition of those as well, something like that.
I think that makes sense, Your Honor.
Okay. All right, so I know the state has provided a jury form that they're going to try to further tailor now that we have a better concept of how we're charging. And I know that was tedious to get through, but I think it was very important that we did it, and it kind of took everybody thinking it through to get to there, so I appreciate that from everybody. And whatever y'all come up with in the way of proposed verdict forms, just forward to Ms. Pursfield. We'll look at all of that. I know y'all need to know when we're going to start the closings. The only things we need, and y'all still need to put those stipulations together. Just pointed out that there are certain overt acts that are alleged to also be an act of, a gang act violation. And we've defined those overt act crimes, and we have sort of defined what a gang act violation is, but when we did that, we only did it with regard to the crimes that were substantive counts of the indictment charges. And there may be there's like an aggravated assault or something like that, and other things. So
Yeah, there's an attempted murder, there's a conspiracy for murder,
so we're going to need to,
drug sales.
I think to keep it clean, instead of trying to.
still
put
keep it
together-
separate.
Yeah, I think maybe we just.
Okay.
The same thing, except criminal gang activity, however we have.
For purposes of this, the overt acts includes, okay.
Do you have to do that? And I'm just saying, I'm throwing it out there because the catch-all says any act of violence, drugs, it lists like the categories. So I mean, an aggravated assault is clearly a violent crime. It's just a suggestion to make it less wordy, but.
I agree with Mr. Abadi.
Okay.
I think I do, actually, with Mr. Abadi. I think that, when we're defining, I don't understand the need, I wasn't gonna die on that hill, but I don't understand the need to specifically say.
These things
Our
equate
criminal
to,
gang activity, and that applies to when we defined it earlier and now. I think we can just, the problem is the definition of criminal gang activity in statute is very long, and then it has the catch-all, and then it becomes,
yeah.
and then you're making references to different statutes as well. Like certainly I understand crime of violence, but then there's the catch-all, and then we would have to reference the RICO statute.
Mm-hmm. And that just gets to be a nightmare. And so when we are doing it for the overt acts, what are y'all saying? Or what are y'all saying that y'all agree to?
I liked what Mr. Abate said, but I also think it's going to get cumbersome if we expect them to parse through everything. But so I would just do it the same way we did it in the first part and just say aggravated, what is it, aggravated battery? Aggravated assault would constitute, if proven, would constitute criminal gang activity.
That goes on first degree.
Yeah.
And where do you want that?
Well, I think if we cut and paste from the first part defining criminal gang or gang act, okay, and we put everything, we copied it and pasted it here as well for the charges for the overt acts, except when we have that little explanation of criminal gang activity, instead of putting murder and those other, we just put aggravated assault.
Can I make another suggestion? Your Honor, is your intention to charge on the overt act crimes first or second? Because my thought is, if we were going to charge on the counts first, you can maybe say criminal gang activity as previously defined, and then just put that last paragraph versus restating the entire charge, just saying criminal gang activity also includes this, and this, so that we don't have to say it twice. That may or may not be simpler, but I'm not sure.
Okay.
I think sorry, I'm interjecting, but I think the issue with that is the overt acts have to be with the RICO charges. Or we say something,
Yeah, I mean,
it could be later, but it has to be clear that these are related to, I mean, because because the overt act is mentioned in RICO, and so it either needs to get restructured or we somehow refer back to it, but it seems confusing if the overt acts are listed way after, totally away from all the RICO.
Maybe charges for overt acts and parentheses as alleged in count 1.
Or if you're doing the overt acts first, you don't have to repeat it the second time
I
when we're
kind of
talking
wasn't
about the
thinking
charge.
about doing the overt acts first.
I think my ultimate point was, I don't think we need
Yeah.
to repeat it twice. We can,
Right.
whichever time we do it, just refer back to.
All right, the gang counts against Mr. Kendrick and Stillwell are 50, 51, and 57, right? So what I could say is, after we define it, for purposes of counts 50, 51, and 57, murder, blah, blah, blah. Murder, possession of marijuana with intent to distribute, possession of a firearm during the commission of a felony constitute criminal gang activity. And then wherever we're doing it for the overt acts, say, for purposes of the overt acts, whatever they are, constitute criminal gang activity. Would that make sense?
Yes, but we have another problem.
Okay.
One of the overt acts is section D of the criminal gang charges. That would be number 182, unless that is out.
Oh, maybe it's out.
I think that's the leadership. It's out, yay.
Is it out? I doubt it. Oh, excellent, okay. I just mean excellent in that it's one less thing we have to deal with.
We said it too.
Okay. All right. Good catch, though, Ms. Persifield. So, thoughts as to whether I do the overt acts in the context of the gang, of the RICO count, or whether I just walk through, here are the definitions, here's how you prove the substantive crimes, the counts in this indictment alleged against these defendants, and then after that, hey, there are also some crimes that are within the overt acts, crimes alleged within the overt acts. Here's how those are defined.
Maybe some sort of transition, like as you see in the indictment, or as you'll see in the indictment, count 1, RICO refers to specific overt acts, some of which are alleged crimes. And then I'm providing these definitions in regards to the overt acts list or something like that.
The question was, any preference as to whether that's done right after I explain RICO or after I explain all of the substantive count crimes?
No preference.
Yeah, I'm thinking right after RICO, Your Honor.
Okay.
It makes sense to just close that gap.
Okay.
But would you include these charges in the
I'd have to.
paperwork, or
Things
just
like-
tack them on at the end as an appendix? And then you could say, look, you know,
No, everything I read is going to go out to them.
no, I want it to go out. I'm just wondering if the charges for the overt acts, if you embed it in the middle of the document right after the RICO section, or I think it may be more helpful to help them distinguish these from the acts and the count, is if you say, look in Appendix A,
Right.
and in Appendix A, you'll see how to understand the charges for the overt acts.
It's fine.
Is that okay with you?
Good idea. The state's nodding assent.
Yeah, yes, Your Honor.
Okay. Man, look at that. All right, so Ms. Percival, you noticed something else?
Yes, I'm sorry.
Better now.
We don't have in the overt acts firearm possession, because there's a number of counts that are possession of a firearm by a felon. There's also a couple of counts that are possession of a firearm by a probationer. And then we have the charges against the inmates.
I'm doing that one. The probationer one is the same, is the pattern that you use for possession of
Yes,
firearms.
substitute probation.
So we'll add that, but then there's several possession of a weapon by an inmate, possession of a phone by an inmate.
I'm doing that one right now.
Okay, a conspiracy for possession by a phone by an inmate. And there's, I don't know if it's in or out, but the Ryan video while incarcerated.
Which number?
Is that a
That is
crime?
Act 180. Is that in or out?
It's in.
Right, okay, so I need something on that.
Well, is that a crime?
I don't know.
We didn't charge it as, we didn't charge the cell phone that he was using.
Okay, all right, but there are some possession of contraband by inmates.
Yeah.
charges,
Okay.
Or acts, alleged acts.
So, isn't, for instance, murder is alleged as an overt act, right? If I am defining all of the crimes that are overt acts first, within the context of RICO, I'm just afraid that I don't know what I'm afraid of. It seems worrisome to me, and to some degree, that then that would be where they find the definition of things that they have to substantively consider against these defendants. You know what I'm saying?
Your Honor, my idea was if you use the appendix for crimes not otherwise defined.
Right. I agree with that.
But, okay,
All right, but then the order of it, I just don't think,
I would say we would use I agree with Mr. Atkins, but I would think that we would do the appendix for the overacts class.
I agree. That's what I'm thinking
Well, yeah,
too.
the appendix comes at the end, so.
Right, but when we charge it, when I charge it, instead of saying, all right, now I've explained RICO to you, and now I'm going to tell you about the crimes that are overt acts. Here's how each of them is defined. I'm just going to say, I'm going to define those for you. If there are any, I'll just get to it later. And I'll do everything that's a count of the indictment. And then I'll say, you know, whatever I'm going to say. My brain's fried at this point.
Yeah,
But
thank you. I'm just a beat
RICO
behind right
refers
now.
to certain overt acts, some of which are crimes. Some of them have already been defined for you, others haven't. Here's the definition. Okay.
Okay.
Okay, what else?
So, so basically here under overt acts, this is in the RICO portion.
Doesn't it? I don't know. We'll figure it out tomorrow. You and I will figure it out tomorrow. Are you saying put that language there?
Well, that's what I'm wondering, is if this is in the RICO, I mean, not all of the
Yeah.
language, but a reference to where overt acts would be.
Well, can't you just put something in there to the effect of see Appendix A for definitions of,
Well, that's the question. Is that
Okay, yeah, an overt act may, but does not have to be a crime in and of itself. That would be the place to say that. Some of the overt acts alleged in this indictment
are crimes? Are
are,
allegedly crimes?
are, well, some of the acts alleged in this indictment, if proven, would be criminal violations, would be crimes. If proven, would be crimes.
Yeah.
Are you?
Are you typing this or am I?
I'm not typing this. Nobody's typing this. I'll type it. Some of the acts, if proven.
Are you both typing into the same document?
We can.
Would be crimes. Some of the overt acts, if proven, would be crimes. I'm just going to highlight that and think about that tomorrow in very Scarlett O'Hara fashion because my brain is not working anymore.
Helps, when you go through the indictment, the way we alleged it, where the overt act is a crime, we've identified the statute that violates. It's very easy. Once
Okay.
you look at it, they'll know which ones.
Okay, great. I may even say that.
Of the overt acts, the
Those
subset
have
of those
a
that are
site.
crimes, those are clearly identified in the allegations, and they'll have that document. So they don't have to guess which is which. It'll say is a violation of the statute.
All right, I may just say something like those will have a cite to a criminal code section. Okay, so I'll think about that more and come up with some language, so,
Tomorrow is another day.
yeah, it may be tomorrow before that gets hashed out, but,
We are working on a redacted indictment as well. So
Okay.
we'll get that tweaked and get that over to the court and everyone as well.
okay. All right.
I think that we need to get together tomorrow and look at all kinds of things again, like hopefully a final jury charge, a jury verdict, what evidence is going to go out, the redacted indictment, all of those things. Which means that closings, which I think are going to take more than a day, don't y'all? I mean, if, I mean, y'all said, I don't know, it seemed like the time periods y'all gave me. Once you think about the fact that people have to take bathroom breaks, that people have to eat lunch,
I rarely take a bathroom break, Your Honor.
that's 8.5 hours by y'all's estimates without any break. So that is more than a day's worth of closings. So I think that means we start closings on Friday, but we probably don't finish closings until Monday. And then I charge the jury, which I hope, I have no idea how long the charge is going to take, but I would think that the rest of the closing and the charge can be completed Monday. They get the case Tuesday.
Yeah.
Well, the end of the day Monday, but I mean, they're not going to do anything in that little amount of time unless I talk really fast while I'm charging. They have a short day on Wednesday. They have a short day on Tuesday also. Oh, wait. This is,
Maybe it won't take them very long.
God, they do. These jurors, and I mean, they are trying to live their lives. I can't remember why we have a late start next Tuesday also.
Saturday?
John, would you consider, I am very afraid of
Would I
closing on.
consider doing all of this after Thanksgiving?
No, that's not what I'm asking. No, that's not what I'm asking. That's what the state has.
And only because, Your Honor, if we close and they take breaks, and say if we don't get a verdict back on Wednesday, you're going home, talking over the Thanksgiving dinner, and you're doing all of this, and you hope that they don't, but you don't know what is
Well, I'm
going.
instructing them not to, and whether they have gotten the case or not, they're not supposed to be doing that.
I agree.
And
I agree. But we would,
I'll get back to you.
we are.
Go ahead.
I think Mr. X told me not to say anything. I'm not.
Okay.
Matt?
Mr. Sharp.
This is my concern about Friday.
Okay.
State judges are opening, closing on Friday morning.
Mm-hmm.
Myself and Mr. Weinstein close on Friday. Jury goes home for the weekend, come back Monday, and then all they hear.
It's like the only thing they hear is the
So
states.
my proposal would be, I don't think everyone's gonna, I don't know this for a fact, I don't think everyone's gonna take as long as we think. I would ask if we could close on Monday, whatever we don't get done, I don't believe it would be much on Tuesday. And then we could give the jury instructions Tuesday, Wednesday, and then they could come back after the break to deliver. I just am very concerned about going for a weekend. And then
Yeah, I mean, I agree. Because the other thing we can do is start the closings and have the state do their open close tomorrow afternoon. And then we finish with the closings on Friday. And then I instruct them on Monday. And they get the case on Monday.
I like the other idea better.
Hmm?
We like the other idea better.
Which was start the closings on Monday, finish them on Tuesday, which is a late start anyway of 11 at the earliest because of a medical appointment. And then I may or may not
have a chance to instruct them on Tuesday, but I could instruct them on Wednesday, but then they have all of that, but then they don't actually start deliberating until they come back from Thanksgiving.
But they would have the written jury instructions.
That's true. They would have them in writing, Your Honor. It's not like they would
Well-
forget them over the Thanksgiving break.
Or we could,
Yeah, I mean, that's,
or Your Honor could instruct them when we get back.
No one listens. They're not actually listening. I think they like it. I think people are more visual anyway. They're less likely to listen for 2 hours to the charge. That's the whole point of sending it.
I don't understand what you're saying, because,
When the court charges the jury, they're blank-faced, so that's why it's always so important to send it back like you suggested you do, because when anyone talks at you for more than 15 minutes, most people stop listening. So, not saying that they do, I know I do.
Then it would seem to be in the state's interest to not have a 5-hour closing, Your Honor.
Easy.
Okay. Yeah, I like your idea for tomorrow, Your Honor, but I don't think the state, I guess the state would not agree to that.
they don't have to agree to it. I've
I
told
do.
y'all for the last 2 weeks, be ready on Thursday to give closings. So if that's what I decide, that's what happens when it comes down to it.
I'm just not looking to throw them under the bus, but I do like the idea for them starting tomorrow, and then we would wrap it all up Friday, or wrap up the closings Friday.
And you like that idea.
I do like that idea.
Only reason he likes that idea is because the jury charge won't be complete until tomorrow, and so he'll have all night to process and synthesize all the information that we'll continue to go over tomorrow.
Yeah.
Mr. Abate is not lying. It's my duty of candor. I have to tell you that.
I appreciate that, Mr. Weinstein, that you take your duty of candor seriously.
Very seriously. You're
All right, so closings Monday, maybe we finish Monday. If not, then we come in late on Tuesday and finish closings, and then maybe we'll just have to see. I charge them either Tuesday and they get the case, in which case I probably just won't. I mean, are they going to deliberate for one day and then go to Thanksgiving?
I would say we could probably close and charge on Monday after Thanksgiving, and then they'll have.
Wait.
We can certainly not close and charge in
I'm
one
sorry,
day.
not close. I meant
You
to say
mean
charge.
Tuesday?
Charge.
No,
On
but,
Tuesday?
On Tuesday.
but I think they should, if we charge them on Tuesday, I think they could begin deliberations immediately thereafter, correct? I don't think
Depending
they-
on what time it is.
We have court Wednesday, correct?
I mean, we're scheduled to have court on Wednesday.
What are the hours?
No, for the whole day.
Well, then that gives them a whole day to deliberate.
I had said, I had told Mr. Matthews we could quit at 2, but Mr. Matthews is no longer in this case. Have we told the jury that? I mean, the jury would,
I don't recall you telling the jury either way about the
Wednesday.
Thanksgiving. We had that conversation at the bench.
Yeah, I don't think I ever did, honestly. So I think they think they're here all day Wednesday. And so they could be here all day Wednesday.
What if when you send your message about coming Monday, let them know that we're gonna have extended hours on Monday. We start at 8:30 and we'll go till 7, so all the closings get done Monday.
And just get all of the arguments. We could do that.
Come on, first thing Tuesday, do the charge.
Well, at 11 a.m. or whenever they're all here, do the charge, get it.
You could extend Tuesday to 7 o'clock, since they're not getting here till 11. Or whatever time.
That's the state's suggestion, to keep them here till 7, just to make that clear.
I'm not staying here until 7 on 2 days, but. And then are you saying have them come deliberate on Wednesday and then take a long weekend and then,
Yes, Your Honor.
okay. All right. That's what we'll do.
Thank you, Your Honor.
Okay. So I still think we all need to get together tomorrow. How about 10?
Oh.
All right.
And there was much rejoicing.
All right. Thanks, everybody. Yes, I think so. We're going to have to get back together on jury charges and yeah.
Hey, Your Honor, they woke up Mr. Kendrick at 2 a.m. this morning. I know you don't have control over
In
the
order
sheriff's.
to get him here?
They moved him at 2 a.m. They woke him up at 2, moved him to Rice Street for whatever reason, then brought him here because I don't know all the thinking behind it, but come on. Can they please not do that? Especially we have a 10 o'clock start tomorrow. Certainly they don't need to wake him up at 2 a.m. again tonight.
I agree. I'm not the elected sheriff.
I understand that.
Doubt
I
if the
understand.
elected sheriff knows that either, frankly. But to my great and devoted deputies, can you all please get word to whomever is in charge of getting the defendants here to, if at all possible, not wake anybody at 2 a.m. to start transporting them for a 10 a.m. court hearing? Thank you. I really appreciate that.
Thank you, Your Honor.